My lord, you have permit to mention for
No.
correction of order.
No. One. এটা টু মেনশন কেন হলো 12:30 টা কি আছে না ওয়ানটা কি আছে The petitioner. Yes. For correction. What do you see? My lord, second page at the top, my lord. Yes. My lord, second page at the top, my lord, Kulodhar Pada instead of Kulodharpur, my lord. Yeah. Kindly come to page 45, my lord. How many times this will be listed on it to be mentioned? How many times? This is the first time, my lord, in list. Are you following the laws? Are you following the orders? Lordships mentioned several locations. Did you follow after the matter was disposed of whether it was posted under to be mentioned or not? This is for the first time. What are you saying? Okay, you don't write anything in the writ petition where he was posted, nothing has been written. Mr. Lady, how many times this will be posted under to be mentioned?
My lord, this was drawn to your lordship's attention. Somehow, inadvertently, it has not been recorded.
But you don't write anything of the posting in your writ petition.
My mistake.
I take up the document and indicate. First, it goes to Bagda East Circle or West Circle. Corrected.
Yes,
Now you say that it is Kuldharpada instead of it is Kuldharpur.
my mistake.
Again, you will come for to be mentioned.
No, my lord, it is kindly
You file an application
forgives
seeking
me.
for correction of the order.
Kindly forgives me for this time, my lord. It will not happen. No, to my mistake, it has happened, my lord.
Is there any other mistake which is present? How many times this will be under to be mentioned? Have you gone through the orders and your petitions and all?
I have. My lord, this second page, top Kulodhar Para would be Kulodhar. Kindly come to page number 45, my lord. Kulodharpur.
Have you written the name of the school in your writ petition?
No, my lord, it is not mentioned.
Inadvertent applicable errors are preempted to order dated 30th January 2026. In paragraph number 4 at page number 2, line number 1, first line, mentioning the name of the school as inverted comma Kulodhar Pada FP school instead of Kulodharpur FP school. The name of the school in paragraph number 4, in second page, first line would be read as Kulodharpur FP School instead of Kulodharpara FP School. Baki the same.
I'm grateful to your lordship,
Yes.
my lord. My lord, I tender my apology, my lord. I'm extremely sorry.
Okay.
Kindly forgives me for this time.
Yes.
Lord,
Right.
this is a secondary matter. Wrongly, it has come before your lordship.
Prakash Laiti, learned advocate for the petitioner, indicates that the matter pertains to secondary education.
Secondary education.
Secondary education. He seeks for release of the matter. In view of the submissions, the matter is released from the list of the court due to lack of determination.
Grateful to lordship.
Yes.
So let this matter appear before the appropriate bench.
Mentioned before the appeal, released from the list.
Yes, grateful.
My lord, this is my application, my lord. My application for restoration, my lord. My paragraph 3 has stated,
Number 2, your lordship.
I mentioned the matter when I was absent, my lord, my junior mentioned, my lord, but time was not granted. That is why matter was dismissed default, and within time this application has been made. Paragraph 3 I have stated my illness.
13 to 19. Here for response number?
Respondent number 2. State project director, your lordship.
Your affidavit?
Service. My service has not been. My affidavit service, my restoration application, I have served. Original affidavit service I have already.
Learned advocate for the petitioner seeks accommodation to file affidavit of service. Let such affidavit of service is filed on the returnable date, list this matter. Well, application after vacation.
Let the matter appear, my lord. My retirement benefit of a teacher, my lord, is being withheld. Only simple question, my lord.
10th June.
Hmm.
থেকে উনি জলপাইগুড়ি দেখবে দিন 10th June তবে ফিরে এসে 10th June.
10 June. Grateful.
Serve and file an affidavit of service.
Yes, my lord.
Next.
Madam, for the petitioner, late Mr. Bari. Timothy Mala till 15th May 2026.
Affidavits have been filed.
Yes,
Lord,
madam.
I am for the District Primary School Council. My order has been challenged, my lord. Report in form of affidavit has been filed in terms of the direction of this one. My lord, kindly let it be posted after vacation, because in the meantime, I do not have any, my lord, further instruction.
This matter is appearing in the list under the heading extension of interim order. Mr. So-and-so learned advocate for the petitioner seeks the extension of interim order granted earlier on 3rd October 2025. Mr. Arindam Chattopadhyay, learned advocate for DPSC Nodia, submits for fixing the matter of final hearing after the ensuing summer vacation. In view of the above, interim order granted earlier on 3rd October 2025 and lastly extended on 30th March 2026 is extended till the end of June 2026 or until further orders, whichever is earlier. Please this matter on June end একটা date note.
একটা দিন দিয়ে দিন। 23rd day. Grateful.
ওটা কি হিয়ারিং এর লিস্টে আসছিল?
Yes. Next also same madam. Same madam.
Where is Mr. Chattopadhyay? He appeared in this matter.
Upon notice, my lord, Mr. Ranjan Saha, yesterday I mentioned this matter, madam.
এটা ভুল হয়ে গেছে গো। This matter is appearing in the list, এটা না ওখান থেকে এসে গেছে, অরিন্দম চট্টোপাধ্যায়ের নাম এসে গেছে, এটা ভুল হয়েছে, ঠিক করে দিচ্ছি। This matter is appearing in the list under the heading extension of interim order. Inadvertent typographical error has crept into order dated 30th March 2026, mentioning the words, mentioning the name of the advocate as Mr. Orindam Chattopadhyay, learned advocate of District Primary School Council, Nodia, instead of Mr. Ranjan Saha, learned advocate for District Primary School Council, Jhargram. Paragraph 3 বললাম? Into paragraph number 3. The name of the learned advocate in paragraph number 3 should be read as Mr. Ranjan Saha, learned advocate for District Primary School Council, Jhargram, instead of Mr. Orindam Chattopadhyay, learned advocate for District Primary School Council, Nodia. Para. Mr. So-and-so, learned advocate for the petitioner seeks for extension of the interim order. None appears on behalf of DPSC Jhargram. In view of the above, the interim order granted earlier on 3rd October 2025 and lastly extended on 30th March 2026 is extended till the end of June 2026. একই দিনে রেখে দেবে। Is affidavits have been filed?
Yes, my lord.
Hearing.
Mark and bless.
I can take. I am for the petition. Let's have the copy. This is the allegation, my lord. I challenge the order of the council, the Madrasa Education Board, that is the my lord, page. Yes. The Secretary of the Madrasa Education Board, minority affair, my lord. That
Page
is the
number?
last annexion. What has happened, my lord?
Page number.
Page number, my lord. Annexure, my lord. Annex page number. Only page. The annexure P6, my lord. Your lordship can say last annexure. Last part one, before one. They have taken a decision, my lord. Against that decision, my lord, I have come before your lordship, my lord. First, my lord, this decision was done, my lord, as per order of the court, my lord. First order is given, my lord. This is the page. First annexure P1.
What was the prayer of the petitioner?
Prayer of the petitioner is, my lord, to cancel the order, impugned order, my lord. That is, to cancel the impugned order dated to 2nd June 2025, as well as, my lord, commanding the respondent initiate proceeding against the respondent number 5, my lord, who himself declared as a headmaster of the school, my lord, though he is one of the trustee. A trustee cannot be remain as a headmaster of the school. So, my lord, I made a prayer before the authority. I came before this court, and Justice Shampar Sarkar, my lord, directed the authority, my lord, to pass a reason order, my lord, and this order passed. This order of Justice Sarkar, my lord, your lordship kindly turn, my lord, the annexure 1, page annexure P1, my lord, annexure P1. In pursuance of this order, my lord, annexure P1. Date nahi.
Date is the answering.
Date. I've served the copy, my lord. I have
Once again, when did you serve?
heavy service, my lord. I have
Served on which date? 12th August. Serve affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for setting aside on and or cancellation of the order dated 2nd June 2025 passed by respondent number 3.
yes.
3 is Secretary, Minorities Affairs and Madrasa Education Department. None appears on behalf of the state. Learned advocate for the petitioner is. What about the other respondents?
Only one, but the private respondent is one or five.
Ghulam Muhammad.
Five and six.
Serve afresh upon headmaster. None has been served.
5 and 6.
Then advocate for the petitioner. Okay. The petitioner again. The petitioner is directed to serve afresh upon the respondents and file affidavit of service on the returnable date. One is headmaster is the private respondent and
Yes, both of them. Headmaster and the private respondent.
5 and 6.
5 and 6.
Achha. Rest are the state. Rest of the respondents are
all are state.
State. It is found that service has not been affected upon private respondent numbers 5 and 6. Petition is directed to serve afresh upon private respondent numbers 5 and 6 to register speed post with acknowledgement due and file affidavit of service on the returnable date. Para. Learned advocate for the petitioner is directed to serve copy of the writ petition and its annexures in the office of the government pleader, High Court, Calcutta, by the returnable date. List this matter on. Follow. Vacation है क्या? जूनियर स्टेशन दिए दो to Bish 24.
The matter will appear on
24th June.
Last question, Your Lordship, directed on 22nd April 2026. Kindly see, my Lord, for Your Lordship's order. Directed to submit further report.
None appears on behalf of the state, nor any report. Any copy has been given to you?
Well, earlier I have served.
Any copy of the report has been served upon you?
Yes, my Lord. That report I have served.
Any copy has been given to you? State has served any copy of the report to you?
My Lord.
Where is that?
This one. Last question, they served before Your Lordship.
What it is wrong?
The नहीं file है?
It is statement of fact. None appears on behalf of the state, respondents, nor any report has been filed. For ends of justice, the matter is adjourned. Is this matter on? Seventeenth.
I'm great. আমি রেকর্ডে আছি না I'm great.
Madam, for the petitioner, let it be remain in the list, madam.
Not today.
Lord, the pursuant to Lordship direction, Lord, the report has been submitted. I have filed the exception to this report.
Where is Mr. Dhar? Mr. Dhar has not come?
Yes. But we have, I guess, all the people.
engaged in some other.
একটু pass over রাখুন।
My lord, the passover I have difficulties, my lord. Passover one another code is my lord. Passover. Make it urgent.
I don't understand. Let Mr. Dhar come.
No, lord, I have the other matters in other code, my lord. So, my lord, if your lord sees Passover, then
Sir.
I am.
Then after vacation. Mr. Mukteshwar Maiti, learned advocate for the petitioner, seeks accommodation.
ওখানে মামলা ধরে যাচ্ছে
None appears on behalf of the Madrasa Service Commission,
37 মামলা ধরে
17 June.
না তো হ্যাঁ এটা কবে করলো
15 and for the petitioner, my lord. The state was, my lord, lastly directed to file a report. Madrasa has already filed. It was the state supposed to file the report, my lord.
Board has filed.
Board has filed, my lord. We have filed. My lord, only contention was page 100. If your lordships kindly take, there was an inspection way back in 2013. That is my contention. It was disputed by the state, and your lordship was pleased to direct the state to file report with that regard.
Where is your application? This is seeking for recognition.
My lord.
Where is it?
Very last annexure, my lord. That too after order of the Honorable Justice Shogoto Bhattacharya. 100 page 120, my lord.
120.
My lord. $116 is the, my lord, coordinate bench.
Lordship, just a small indulgence, Your Lordship, that as per the order passed by the Honorable Justice Swagata Bhattacharya, it was stated a petitioner to submit a fresh application for seeking recognition of the concerned madrasa in accordance with law. In my affidavit, paragraph number 6, Your Lordship. Paragraph number 6. Fresh application in the prescribed form and manner, including Form 1, has been received by the board. It is further submitted as Rule 4.1 of the rules relating to inspection. Until date, the board has not received any inspection report from the appropriate authority in respect of the concerned madrasa.
But this application says that there is a DLIT inspection has already been made.
My lord, but the DLIT team, it was supposed to submit us a report. As of now, we have not received the report, and as such, my lord, the state may file an report stating their contentions, Your Lordship.
Find out Mr. Samimul Bari. What is this? Mr. Bari. He appeared for the state. He was to seek an instruction whether DLIT report has been filed or any inspection team has conducted any inspection or not.
Your Lordship.
That is only required.
My lord, that is what the your lordship's that direction that was only to that effect.
Ask Mr. Bari to come. Samimul Bari. একটু pass over রাখুন।
Great.
Well, I am for the petition on that. Let this matter, my lord, be adjourned till after reopening, my lord. This is a matter relating to, my lord, the interest on the area.
State will be required.
So state is ready. What also body?
Petitioner is represented, none appears on behalf of the state. কতদিন চলবে এরকম গো? কতদিন চলবে জুলাই করে? ভালো অনেকদিন হয়ে গেল। None appears on behalf of the state. For ends of justice, the matter is adjourned 17th June.
17. Next one also under the same.
Same order.
17.
16 and 17 same.
South Africa.
I am for the petitioner.
Well, directed the state authority to submit a report, my lord. Your lordship can see last occasions. This is, my lord, the overdrawn amount. The petition is not getting pension.
Due to that overdrawn,
Yes,
but he has been directed to deposit that amount.
yes. And my lord, your lordship directed the state respondent to produce a report, prepared a report.
It's such report, yes, district inspector. Petitioner is represented, none appears on behalf of the state, nor any report is filed pursuant to order of this in terms of order dated 22nd April 2026. April tarike ka? After the vacation,
The matter will appear on 17th,
17th.
May, June. 17th June. MD.
19, I'm appearing for the petitioner lordship, paying for not today in this matter.
Not this week, next.
Your lordship, I am for the petitioner. Your lordship, I am paying for not today.
Why? Date is there, date is required. Bipin Ghosh appeared.
This is the sub and substance of the matter, your lordship. Our group D staff, not our group D, as person, some casual employee was employed in the year 2021 and in an unsanctioned post in the year 2022, the gatekeeper of the madrasa, he died. Thereafter, upon his death, the casual employee, he is seeking a permanent employment in the madrasa as a group D staff, which your lordship is well aware of the fact that after 2009, the Madrasa Service Commission has come into being. So any such appointment, whatever, it has to sail through the West Bengal Madrasa Service Commission. And your lordship, the petitioner concerned has not impleaded the Madrasa Service Commission as a necessary party as well. So this writ petition itself is infactual,
Your lordship,
for
I am
want of jurisdiction.
No, how?
Prayer, your lordship, may come to page 12, the asking the respondent authority, Madrasa authority to take immediate steps for the absorption and regularization. So how regularization can even be done when the job is for only if casual vacancy, if there was any, so it is for only a period of 4 years, your lordship. So
So
none of the,
who is the answering respondent file a report? What was the status of the father? Because
he was not the father. It is not in respect of dying in harness, but this is a casual employee was employed in the madrasa in thereafter 2021 2022 there was a permanent employee. He was the gatekeeper of that madrasa. He expired. Upon his death,
okay,
this person, this casual employee,
now
he
he
is
seeks
taking claim that he should be absorbed. So as of now, there is no such regulation, no such ruling from the apex court also, because his job is for only a period of 4 to 5 years, your lordship.
Yes.
Your lordship, can you please give a short passover, your lordship? Mr. Banerjee is appearing in this matter.
Mr.
He is engaged in court number 24, your lordship. Can you please give a short passover?
And who is the answering respondent in the service commission?
Look, they have not implemented service commission as one of the necessary party, your lordship.
Oh,
পরীক্ষায় তো দিয়ে তারপরে আসতে হবে, কিন্তু এই ক্যাজুয়াল ভ্যাকেন্সি কি করে, whether this, and it has to also be to ascertain whether this casual vacancy it arose and whether there was a resolution by the managing committee, whether it was approved by the DI. So I guess the DI is also the answering respondent, the state authority. So the DI also has to state whether this employment, irregular, regular, whatsoever, what is the position, and the school authorities as well. But I guess the school authorities is also not present today.
But he is a party, your
Where
lordship.
is your affidavit? Affidavit of service?
Yes, yes, your lordship.
It is not a party.
Party.
School is a party, your lordship.
Serve, serve.
10.
Serve.
Yes, this is affidavit of service. And DI is also a party.
হ্যাঁ DI আছে আমি দেখেছি তো সার্ভিস কমিশন কেও করতে হতো না না আছে আছে এই তো কমিশন শুধু না DI আছে মাদ্রাসা আছে লালগোলা
Service
Precedent.
বলছি যে রিটায়ার করছে মডেল কেন এটাই তো judgment को भी सभी करें সব দিয়ে দিয়েছি এই তো এটা স্টেট এটা তো সবাই তো এক দুই তিন চার এই না
হ্যাঁ
এটা হচ্ছে সার্ভিস কমিশন
ভ্যাকেন্সি থাকলে তারপর থেকে রিকুইজিশন DI কে যাবে DI রিকুইজিশন ফরওয়ার্ড করবে সার্ভিস কমিশন terminated model
Non-appears affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for a regularization of his employment
নাম দিতে হবে
as a Group D in the Lalgola Rahmatullah High Madrasa HS. On the prayer of learned advocate for the petitioners, leave is granted to. This is West Bengal Madrasa Service Commission.
your lordship.
Granted to implead West Bengal Madrasa Service Commission as added respondent number 11. Petitioner is directed to serve the copy of the writ petition and its annexures to added respondent number 11 and file affidavit of service on the returnable date. None appears on behalf of the state list in the 17th. On 17th, make service upon the service commission. Leave is granted, you add service commission.
সার্ভিস কমিশনকে পার্টি করতে বললো
DI is the main answering respondent.
If may kindly put the situation in this way. Suppose any vacancy if it arose, the managing committee, concerned managing committee, it seeks a requisition from the DI. The concerned DI, after inspection, they forward it to the service commission, and the service commission, upon recommendation, that has to be done. This is what the general ordinary parlance of law.
Serve upon the service commission. Next.
Madam for the petition. My lord, here my prayer, my lord, is for grant of the higher scale of pay, which issue is, my lord, no more res integra. I'm already covered by the honorable special bench and thereafter the honorable single bench and the division benches as well. So, my lord, the very short fact of this matters, my lord, is that this incumbent, my lord,
Without the state, how can you take it up? State will be necessary.
could I just, my lord, pray before your lordship? My lord, since this matter, my lord, pertains to that, I was already, my lord, pursuing my MA course. While, my lord, I was,
Permission is not required. You have taken permission.
my lord, I was pursuing the MA course and thereafter I was appointed. MSc. Thereafter I was appointed. So I already did my first year of MSc.
Part one.
Then, my lord, yes. So
Okay.
which is already covered by the honorable special bench as well as by this honorable courts as well. So, my lord, I pray before your lordship, if my application, because I prayed for higher scale of pay and it is no more disintegral that I will not be paid. This cannot be a situation. So if the, my lord, authority, my lord, could take into consideration my prayer, my lord, keeping in mind, my lord, the judgment that I'll be citing before your lordship, that
No.
you'll also do.
I make it not today. If
As-
before vacation, if the panel is there, a representation from the state is necessary.
So if your lordship, my lord, if it could, my lord, permits, my lord, if it could be, my lord, posted on the next week, possibly within that,
I'm
my lord.
making it not today, it will automatically come in the next week.
Great.
You keep it on that day.
What then, Chair? As your lordship, please. Great.
23, my lord. Kindly, I'm saying for not today, my lord. State is not there, my lord. Just don't get you.
On the prayer of learned advocate for the petitioner, leaves this matter on 17.
Twenty-four, I'm applying the petitioner, my lord. Keep it, my lord. List, my lord.
Next week,
Next week, my lord, keep.
not today.
25,
I'm for petitioner, my lord. Paying for not today, my lord.
Next week.
26. I'm for the petitioner. 27.
My lord, I beg to appear for the petitioner, my lord.
My lord, I'm for
Petitioner.
the commission. My lord, senior advocate 40 is engaged in court number 11. I'm paying for not today.
May I just start, my lord?
কতটা পাস ওভার আছে
No,
করবে না সেই হিসাবে বলে দাও না বলে দাও একবার বলে দাও
He has been removed.
Yes, he was a headmaster.
Why?
Then there was an appointment letter in 2013. There was an appointment letter in 2015 appointing him as a headmaster as well, because the Madrasa went from senior to high. Now he is an assistant teacher somehow. That is the point of challenge. Now, my lord kindly comes to page 17. That is the appointment letter given to the petitioner.
No, why he has been removed?
There is no reason, there is no show cause, there is no proceedings, there is nothing.
Ask Mr. Dhot to come. State might be not be the necessary party.
May not be,
It
may
is
not be.
required. Your lordship, why I say so, because this is an unaided madrasa, your lordship. So
But a recognized one.
How?
unaided. So unaided, there are such honorarium which has been paid, and moreover, whatever if some person was appointed as a headmaster, thereafter he was removed from the post. So whatsoever it has to be done, the same has to be notified to the DI schools. So the DI is a necessary party to this proceeding. DI.
DI has not been made a party.
DI, I guess DI is a party. I think.
No, district inspector of schools is a party.
No, the Madrasa Commission and the Madrasa
Pass
itself.
over. Pass over. Ask Mr. Dhot to come.
DI কে পার্টি করতে হবে তাহলে হবে না
Similar, the next matter is identical since he was a teacher. Now he is not even on the faculty roster.
28.
Similar.
Same pass over. Let Mr. Dhot come.
Your Lordship, I'm appearing for respondent number 6.
Not today. Ajay, Dr. Order. Your response number 6, headmaster. Or what is the prayer in the writ petition?
There has been no prayer against me, Your Lordship. The allegations have been made out against me.
अरे not today वो लेकिन date টা দিয়ে রাখছো না পেছনে date টা দিয়ে রাখেন তো not today date
I'm for the petitioner, my lord. Sir, kindly bring for short passover. The matter is that, my lord, I am challenging the transfer order, my lord. I am led by Mr. Shah.
where is the transfer order
Okay.
Okay.
At page 27, my lord, this order was passed in my favor, my lord.
27
As per 27, my lord, as per vacancy report received from the Union High Madrasa, it appears that the post of librarian is lying vacant. Consequently, the role of librarian is
লিখে দিন না
full file দিয়েছেন
30 31
ও
কত রেখেছো 30 what is the name of the petitioner
নার্গিস নাসিমা বেগম 27 মিনিট পেজিনেশন ভুল নেই তো
page 30
27
27 yes
the order on the heading led first paragraph there was a vacancy reported second paragraph now in terms of rules so Nasima Begum librarian presently working in so Madrasa is hereby recommended for special transfer. Now this was done on 8th May 2025. So in terms of this recommendation, letter of appointment should be issued, Namlet page 28 in the month of September. This was in the month of May and the September.
yes
With regard to the above subject and the reference, I directed you to request you to apprise the commission on the following details. Then student strength, transfer, effect of the transfer of librarian, then other so. This was sought for by the commission. So commission was aware of my recommendation. Now at page 29, I made a representation which is at page 31. Where I have prayed for issuance of letter of appointment so that I can join.
this is letter of recommendation
Yes.
or
At page 31, my representation.
no the service commission will issue a letter of
Recommendation. Following the recommendation of the state.
So
This
has
letter I
no
have,
winter.
this dates are relevant, page 31 on 26 February 2026 and the mail I was email I was made on 26 February 2026.
Okay.
Now, my lord,
Who will provide these documents? It has been called for from the secretary.
these documents will be
Directorate.
provided by the school, the madrasa, concerned madrasa.
So they have called it from the directorate, which has
So
passed the order.
yes, they have the all information. They have all information, right? Now, when this issue is pending, my challenge is at page 35. Certainly, my lord, I have come across, in respect of the same post, somebody has been recommended by the commission, despite having all information they have. That is my challenge.
Oh,
When
okay. Same post.
same post,
Oh, how many librarians are there
one,
in the place which you have transferred to?
yes, one.
And this has been issued on which date? 26.
Later on 25th February 2026.
Ask Mr. Dhod to come. It takes to Mr. Dhod, I will follow. This person has joined.
That I don't know, my lord. Possibly no. My information is no, my lord.
But then here is that the recommendation cannot be issued or this is rejected. No such communication has
I don't have any information beyond this.
Okay. Just passed over. Let Mr. Dhor come. He will. नहीं गया. Same.
सर्विस कमीशन पासवर्ड चाहिए सर.
I am for the petitioner. Petitioner for pensionary benefit manner by changing the name. After filing the writ petition, my lord, they have communicated one letter, man. This is the affidavit of service. Yes, if your losses kindly direct the authority to conclude the proceeding within such and such period, my lord. This notice has been issued, my lord, after filing the writ petition and copy served. Or the writ petition copy served. They have intimated me regarding the change of family pension memo in PPO. This is the letter, my lord. They have given me after getting the copy of notice. And I have submitted through my assistant teacher, my lord. Submitted all documents. If you let's say kindly direct the authority to conclude the proceeding within a stipulated time, my lord, that should be better, my lord.
You have submitted the marriage certificate?
Yes, my lord. I have submitted, my lord. I have given one copy, my lord. After giving that letter, my lord, I have submitted all documents, my lord.
What is this letter?
Yes, my lord. Yes, in this letter, my lord, regarding change of family pension on 24th March 2026, they issued, my lord, notice. And not submitted marriage registration certificate of late Mr. Abdul Latif and Sunara Bibi, the original affidavit legal year certificate, and immediately thereafter, through my lord, my teacher in charge, I have submitted on 6/4/2026. This is the document, all documents.
next week রেখে দাও next week রাখো next week this will come up. Okay.
Thirty, 34, my lord. Mr. Abu Soil is appearing for the petitioner, my lord. He is not present, my lord. I'm praying for not this week.
Next. 35. Not today. 36. 37. 38. Pass over the
Yes, my lord, for our petition, my lord, today I have no brief, my lord, just my lord, not today.
without the brief you have come to court. Not today. Passovers. Where is Mr. Dhar? দেখো তো পাস ওভার একটা ছিল মিস্টার বাড়ি 15 এ পাস ওভারটা দেখো
তিনটে তাহলে দিয়ে দাও করে দাও
ইয়েস
সে আমরা পাইনি জিনিসটা বলবে তাকে একটু বলবে ওটা আমাদের আরো পাঠিয়েছে
এই ডিস্ট্রিক্ট লেভেল ইন্সপেকশন টিম হয়েছিল সেই রিপোর্টটা কোথায় আছে সেটা জানার জন্য
Difficulty is that that we are not appearing in any state matter right now. That's the whole difficulty.
Difficulty is you are also not getting any report or information to dispose of the matter. What is the position, Manu? The government leader has been appointed.
Before the vacation.
Not yet.
And the Advocate General?
Not yet.
No panel has been prepared yet.
Mr. Rahman, we place it after the vacation then.
Okay, better.
Mr. Petitioner and the Madrasa board is represented. None appears for the state. For ends of justice, the matter is adjourned 17 June.
Grateful.
May I require to, my lord, start again, my lord, after.
You have to, I suppose. They will not be in the panel.
Only the honor GP, my lord.
Yes, only GP.
Learned advocate on record for the petitioner is directed to serve a copy of the writ petition along with its annexure in the office of Government Leader, High Court, Calcutta by the returnable date. ধর এসছে কি করবো
Petitioner.
দেখো পাস ওভার দেখি
I appear for the petitioner. If Mr. Dhar is not here, let it retain his position. Let it come up on the next.
On his way. He is coming. He is coming.
Very well, my lord. May I just start in the meantime? What I was just pointing out.
Yes.
Yes. Page 17, my lord, kindly comes. This is the initial appointment letter my lord will find. That is dated 28th of December 2013.
Yes.
By virtue of which my lord will find a resolution and the appointment of the petitioner as a headmaster of the institution.
Right.
Right. The my lord, thereafter, my lord will find the joining letter, which is at the page 18 or 8th of January 2014. That I have appointed the head teacher, staff at Jobaida Model Senior Madrasa.
No,
Next
this is not the joining letter.
No, well, this is I have joined. I have been appointed. That much is there.
Yes. Where is the
So,
joining
my lord,
letter?
joining letter that is in a crux joining letter because that will find its position in page number 20. My lord, that is the faculty roster. My lord will find Mohammad Shamim, the name of the petitioner at the top. HM.
Yes.
That is the headmaster. Subsequently, this senior madrasa converts to a high madrasa. So a separate appointment letter was issued. That is, my lord will find it at page 21.
Yes.
25th of December 2015. Jo headmaster of Jobaida High Madrasa, and the joining letter as well in the next page. I wish to join as a headmaster in the post of Madrasa today on 10:30. My lord, got it, my lord? Now, subsequently, this Sahanara Khatun, which is a private respondent, she joins to the secretary, my lord, as an assistant. Page 23, 8th of January 2022. Prayer for joining an assistant teacher in the post
Anybody?
of.
Is any junior is there?
Yes, my lord.
Any junior of you is here?
Yes, my lord. Yes, before your lordship.
Where is the affidavit of service?
Well, it's with me, my lord. I'll file it within the course of this day. Its file is with me. I'll filing. It has been served upon everyone, my lord.
Sir, I have to see whether you have served upon the private respondents or not.
Yes, my lord. I have served. I have the affidavit of
No,
service,
that
my
is
lord.
your submission. I have to see whether the service is complete or not.
Well, they very well, my lord.
Private.
May I just.
Well, I'm very sorry. I was in court number 11, so that's the reason.
May I just conclude, my lord? After that, my lord, I'll submit the affidavit of service, my lord.
Anyway, continue.
Yes, my lord. The joining letter of Shahanara Khatun, my lord, will find at page 23. That is, she joins as an assistant teacher. And my lord, see one more vital point that yours faithfully Shahanara Khatun joins us thereafter the care of Shamiruddin Sheikh. My lord, at the bottom portion, after her signature, care of Shamiruddin Sheikh. That Shamiruddin Sheikh is the secretary of the madrasa as well. My lord will find at the left portion of page 23 at the bottom.
Yes.
That's the secretary. Now, even after, my lord,
yes, continue.
Even after her joining, a faculty roster was being issued at page 24. Well, my lord will find my name as at the headmaster, next page, Mohammad Shamim. And the Shahanara Khatun was an assistant teacher. Now, my lord, all of a sudden, a notice has been issued, rather an appointment letter has been issued, which is at page 34. It's dated 25th of December 2015. But the reference, my lord, kindly comes to Wide Managing Committee Resolution Meeting number 2 of 2023, dated 5th of February 2023. The resolution takes place is February 2023. The notice is issued in December 2015. And the subject is appointment letter in the post of assistant teacher as history in the Jobaida Model High Madrasa unaided. That is issued to the petitioner. I was appointed as a headmaster in 2013. In 2025, I have been issued a letter to be appointed as an assistant teacher. That is my grievance. And after filing this writ petition, my lord, whatever honorarium, whatever remuneration was being paid, it's being paid to the assistant, all the teachers, bar me.
Yes.
This is sum and substance of my grievance. There's a representation as well, but non-consideration thereof as well. That much.
Yes, Mr.
But there is a representations. Well, may I seek some instructions or I can file a report on that? Because there are two ways, my lord. One is it can be simpliciter disposed of because there is a representation, so we will take a decision. But it might also happen that even it may not be a such case. May I take instructions. Lordship may
This
pass
side of
an
the
order so that
application
we
is
can come
possible,
up.
my lord.
Yes.
Lordship may pass an order, we can come up with a short report.
কি করবো না affidavit তো দেয়নি I will peruse the affidavit of service.
My lord, may I just pray for this matter to be taken up to, I'll be before your lordship at 2, my lord. Just for the
No.
sake of this affidavit of service, I'll be before your lordship, my lord. That much I pray.
You do one thing, you send that affidavit of service screenshot to your junior.
Yes, my lord, I am sending.
You forward that, let me peruse that. In the course of the day you file.
Very well, my lord. I'm sending it, my lord.
Show me, huh?
I'm sending.
Affidavit of service filed on behalf of the petition is taken on record by the present writ petition, the petitioner. Seeks for taking aside of the letter of appointment dated 25th December 2015, issued by respondent number 5, Secretary Jubaida Model High Madrasa, VD memo number JMHM/04/2023 within bracket annexure P11. Mr. So and so, learned advocate appearing for the petitioner submits that the petitioner was appointed as a headmaster of the said Madrasa, which was initially named as, what was the initial name?
Jubaida Model Senior Madrasa, which was
Jubaida
turned into a
Model
High Madrasa.
Senior Madrasa and subsequently renamed as Jubaida Model High Madrasa in the year 2015. The roster of the school, roster maintained by the school, shows that the petitioner as headmaster. However, by the impugned letter dated 25th December 2015, annexure P11, the petitioner has been directed by the secretary of the said Madrasa to join as assistant teacher of history. The action of the secretary is arbitrary. Hence, the petitioner is constrained to file the present writ petition seeking appropriate relief. Mr. Pratik Dhol, a senior advocate appearing for Madrasa Service Commission, seeks to file a report. Let such report be filed within a period of 2 weeks. List this matter after 2 weeks of vacation. Vacation for date bolun. Date ta bolun. 10th June. Next.
Now, the next matter is with regard to the only thing the assistant, if the petitioner was an assistant teacher, say, identical institution, his name is not even appearing in the faculty roster anymore.
My lordship may pass the similar order.
Similar
And only
order,
one thing, instead of 10th June, can it be, my lord, on
Subsequently.
yes, 1 week after.
The 17th June record.
Yes, 17th.
17th June. Now what happened? She joined as an assistant teacher.
Yes, my lord will file on page 12. That is the appointment letter as an assistant teacher.
But now her name is not appearing in the roster.
His name is not even appearing in the roster.
By the present writ petition. Where are the other pages?
Next page.
The next-
Slide.
From the affidavit of service, I see, my lord, there are two notices were not being, it is says as a item invoiced. Since they are filing a report, my lord, may I serve again in the meantime upon the non-served respondents in the meantime, my lord?
Which are the respondents not been served?
Now, my lord, the state authorities have been served. The itself, the madrasa itself seems to be not have been served, my lord. It says item invoiced.
And the private respondent?
That is there is no private respondent. The headmaster, the Shahanara Khatun, who was the private respondent, is the current headmistress of the institution, who was the assistant teacher.
Okay.
There is no such as private
The
respondent.
affidavit of service, Surit Babu, on the prayer of learned advocate for the petitioner, liberty is granted to serve afresh upon the
Non-appearing respondent.
Headmaster or headmistress.
Non-appearing respondents, man, that much only.
Okay. Non-appearing respondents. By the present writ petition, the petitioner seeks direction upon the respondent authorities for reinstatement of the petitioner as assistant teacher in the Madrasa, namely Jubaida Model High Madrasa. The petitioner contains that Mr. So-and-so learned content services submits that the petitioner joined as an assistant teacher in the said Madrasa and her name was appearing in the roster maintained by the said Madrasa. However, subsequently, from which year this is missing?
2020. 2024, my lord.
However, her name is
His, my lord, it's a his.
His
Abdul
name is
Jahid.
not appearing in the roster since the year 2024. Mr. Dhor's submission টা ওই আগেরটাই হবে। 6 to file a report, huh? Let such report be filed within a week, 17th June. Same
I'm
date,
grateful.
17th June.
Yes.
I'm grateful, man.
Transfer. এটাও করে দেবে কপি। Mr. You send the affidavit of service.
Yes, my lord, I am ready. I'm filing today, my lord, before your court officers, my lord.
This is Mr. Dhor. This is regarding a transfer which was recommended in 2025, May 2025.
Yes.
The commission sought for some documents. However, thereafter, no recommendation was made by the commission. Now, at page 35,
Yes.
another person has been recommended to be appointed in the same post.
Madam, may I, would your lordship kindly keep it on the next Tuesday? Because if I find that it is, if I find it is really illegal, then I will say so.
Okay.
Only I'll be expecting that if no effect is given to this.
Next week.
I'm saying I will come only these dates.
Affidavit of service filed on behalf of the petition is taken on record by the present writ petition. The petitioner seeks direction
my lord,
upon the
the transition period, what is happening, if I had the clear instructions, then I could have clearly said, because I also have, before I say anything confidently, I have to double check. That's the reason, my lord, I have not taken aside just a point of law. It is very well possible that my learned friend is right.
Okay. Seeks for implementation of the recommendation dated 25th February 2026. Now, where is your recommendation? Oh, sorry, to give effect to the order dated 8th May 2025, issued by Directorate of Madrasa Education, transferring the petitioner to which place? To Union High Madrasa, HS, District Hooghly. Mr. Shamim Ahmed submits that despite such order of transfer, the recommendation letter has not been issued by the West Bengal Madrasa Service Commission. And in the meantime, another person, he has been made a party.
I don't have his particulars.
In the meantime, another person, namely Sheikh Ibadur Rahman, has been recommended to be appointed as a librarian in the said school. Mr. Pratik Dhar, learned senior advocate appearing for West Bengal Madrasa Service Commission, seeks short accommodation. List this matter to take proper instruction. List this matter. Next speaker.
Let me add one line that I have taken instruction that he has not joined yet.
Mr. Ahmed informs the court that the person who has been recommended has not yet joined.
This is my lord, very short matter. Affidavit service টা নিন তো।
Yes.
My lord, 10 person were appointed in this madrasa, my lord. At page at page 24, annexure P3.
Page?
P3, annexure P3.
Page number?
24.
(24).
10 person. Name of teaching, non-teaching is teaching staff.
Yes.
Last one, Mohammed Abdul Latif Sheikh. Well, 9 are granted remuneration, not honorarium. Only it is unaided madrasa. They are getting.
One thing I should say for my honorable proceedings, because there are some matters where, as a commission matter, I will take decisions, therefore no requirement of states. But here the release payment, it is directly with the state. I don't think in absence of the state councils.
CME is required, Directorate of Madrasa Education, and the representation is also submitted to
Prayer, we kindly have a look at prayer. It doesn't come within my domain.
Okay.
Government.
Which is the authority? DI.
DME.
DME.
Directorate of Madrasa Education.
Is a party. DME is a party here. Yes, Minority Affairs. By the present writ, affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for a release of honorarium in his favor. none appears on behalf of the state. Please this matter for ends of justice, the matter is adjourned. June মাসের 17th June.
17?
We have a panel. Huh?
17th June, sir.
17th June.
Next. Over. নামি 12:30 ডেকে এখন ইউই করে কিন লাভ নেই নেমে বসি 12:30 সময় 12:30 নামি ওকে ডাক বসে থাক
Hearing matter. My lord, my item number is 87, 88 hearing. 88, 89. Can it be taken up faster? Faster? Because as per your lordship's direction in the list, second up is fixed for assigned matter, specially fixed assigned, then criminal matter.
So 12:30 matter is there.
38.
There is a 12:30 fixed matter. Item number 1, 2, 3.
Oh. May I take a little indulgence? Nothing to do with this matter. Lordship has delivered a judgment that negative mark. Everything, in fact, in the paragraph, Lordship has referred also. Now, somehow my name has been missed out because it was all the.
কালকে to be mentioned.
To do with Lordship's correction.
কালকে to be mentioned দিন Sorry.
No,
I would have seen that.
On my
Because you argued at length and your name has been missed out.
Sometimes what happens that it is nothing to do with the billing, not for that. It is a judgment where Lordship has dealt with a point of law. If I can say very honestly, we feel good to be part of when the law is being framed, only for that purpose.
Okay. কালকে to be mentioned. We'll correct that. 12:30, I'm just rising now. At 12:30, I'll call the list.
I can't do that.
Time for the applicants. Mr. Shamim was appearing. He was about to Firdaus Shamim.
Also, my senior came and told about like in the last occasion also my senior came and told to for refixation of the date, my lord.
Well, instead of refixing my lord, today may I conclude my argument? So let Mr. Firdaus Shamim conclude on the next day.
You are for?
I am for the applicants in the addition of party application, my lord. Can one?
As far as I am concerned, my submission was over, and I also prepared a short note and on the last occasion handed over. Now, in case that is somehow misplaced, so I have kept another one also. In case.
We can
I can let my lab.
we will
Yes,
check and then.
I have understood. That's the reason. This is a common thing. So many papers. I keep it with me, but maybe at the end I will do.
So that it can be. Well,
Hearing of this, but this will open a time frame. I have taken like 15 minutes. This is not taken like half an hour.
I'll finish it today, my lord. There is enough time. My lord, first of all, my lord, my application is allowed. My lord, we fall under the category.
No, this is true.
Well, we were the applicants in the CAN 1. Our application for addition of party was
CAN 1 of 2020.
Allowed, my lord.
5.
2025, my lord.
25 in which
In
WPA?
WPA 3562 of 2025.
3562 of 2025. Yes.
And my lord, we are total 67 candidates in number.
This CAN has been allowed.
CAN was allowed.
67 candidates.
And these 67 candidates, my lord, they were the pursuing candidate at the time of issuance of the advertisement. But before the examination was held, they had obtained the degree, the necessary training.
This is they were pursuing DLED.
Lordship,
Which
yes.
course?
That is B.Ed.
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 All.
They were pursuing, but Lordship, before conducting the examination, they have completed. Now I have prepared a small list of dates, my lord.
Before.
My lord. একটা copy দাও তো, sir.
On which date this B.Ed was completed?
Yes, my lord, B.Ed was completed by 8/12/2023. 8/12/2023, and ultimately the admit card of the TET examination was issued, my lord, on 28/1/2024. And result of the examination was published on 21/12/2024. This was the result of the TET examination.
Okay.
Thereafter, main examination was followed. So, Lordship, my stand is all 67 candidates, they had their necessary qualification equivalent with the petitioners, writ petitioners, on the date of the examination for the teacher's eligibility test. My lord, I have a primary objections on the maintainability of this petition. And I humbly say, these petitioners have belatedly challenged an action which was taken by the Madrasa Service Commission and which was publicly notified by the notifications and published on the website. Lordship, kindly come to the writ petition once. I am referring to
ABM Abdullah, WPA 3562. And my lord, kindly come to paragraph 2 onwards. What is the awardment? Petitioner state that by an advertisement dated May 13, 2023, the respondent West Bengal Madrasa Service Commission published advertisement for the 7th state level selection test as well as teachers eligibility test. Initially, the advertisement in Note 16 stipulated that qualification will be as on the last date of the application. Therefore, prospective candidates must have acquired all requisite qualification before the last date of application. Copy of the said advertisement dated May 13, 2023 is annexed hereto and marked as Annexure P2. 3. Petitioners state that having the qualification for recruitment to the post assistant teacher, the petitioners made their respective applications. All the petitioners have obtained their Bachelor of Education degree prior to the last date of application. Now comes the most important paragraph on the basis of which I say petitioners have not only belatedly approached, but they were very much negligent about the entire procedure. Lordship, kindly come. Petitioners state that surprisingly, on the date of the main examinations, they were the examinees. They went to write the examination. On the date of the main examination, that is on January 19, 2025, the petitioners were shocked. They went to write the examination. They had the time to find out, shocked to find out that many candidates who did not obtain their training qualification prior to last date of application had been allowed to participate in the selection process in complete violation of the extant norms. My lord, here, Lordship, kindly consider this fact that the petitioners, they went to write the examination. They had the time to find out who are not having the training qualification prior to the last date of applications. So the foundation of the entire writ petition, my lord, is vague in my humble submission. My lord, thereafter, my lord, kindly come to paragraph number 7. The petitioner states that the aforesaid notice dated 12 June 2023 has no legal basis because the order dated 9 June 2023 never implored the commission to include candidates pursuing B.Ed course to appear in the main examination. Now, Lordship, kindly come to the notifications 1. Lordship, kindly come to page 66 of the writ petition. This is the notification for the state level selection test assistant teacher in 2023, and Lordship, kindly Lordship should keep in mind that these are the posts related to the West Bengal Madrasa Service Commission will conduct 7 state level selection test assistant teacher for the recruitment in 1729 tentative vacancies for the post of assistant teachers for classes 9-10 and classes 11-12 and TET Advanced Arabic for classes 5 to 8. Lordship, we fall under this, that teachers eligibility test. Lordship, there are 2 parts. For Lordship, kindly read it once. The recruitment of 1729 tentative vacancies for the post of assistant teachers in class 9-10 and class 11-12. And teachers eligibility test, Advanced Arabic for class 5 to 8 and Arabic undergraduate for class 1 to Arabic UG for classes 1 to 4 in non-government aided madrasas of the West Bengal as per West Bengal Madrasa Service Commission Recruitment, Selection and recommendation of persons for appointment of the transfer to the post of teachers, non-teaching staff rules 2023 and the NCT guidelines. So, Lordship, this examination was conducted under the guidelines by the NCT and the necessary rules of 2023. But it kindly come to note. Now, note 16, qualification will be as on last date of application. Now, Lordship, here my submission will be, since there are two sets of law to regulate the entire recruitment examination. One is the necessary rule of the Madrasa Service Commission, and another is the NCT guidelines. And Lordship, we are today dealing with something which deals with the eligibility of the person. And we are dealing with a question which asks that whether a person who are eligible to participate, the NCT rule says that those who have the qualifications, minimum qualifications, to be appointed as the teachers, assistant teachers, and they requires these training qualifications. So far this qualification is concerned, all of us, we were within the zone, we had already appeared in the courts, we were pursuing the courts, examination was not conducted for the courts, and this Madrasa Service Commission was also not prompt to complete this recruitment examination. The date will show that the time they have taken to conduct this examination. And they themselves has issued the necessary corrigendum, which is annexed in page 74, that is P4 of the writ petition. My Lord, kindly come. The corrigendum to the earlier notification which I have shown, it is notified for the general information of all concerned that the last date of application for 7th SLST is hereby extended up to 19/6/2023. Lordship, it is not only allowing some people to participate in the examination who did not have the qualifications prior to the last date of examinations which was earlier notified. It is also extending the last date of making this notification. So they have extended the time also. So last date has been extended. Thereafter, corrigendum 3 was included. It is also notified for general information of all concerned that note 16 in information guidelines for 7th state level selection test assistant teacher 2023 may be read as qualification will be as on last date of application, provided that a candidate having B.Ed approved by RCI or candidate pursuing B.Ed approved by the NCT or RCI may also apply subject to fulfillment of other terms and conditions. My Lord, it is not only allowing a class of candidates in the examination by relaxing the rules or relaxing the guidelines or relaxing the conditions given under the advertisement, but also extending the time, that is for cut-off date. They have also extended the cut-off dates. So the fundamental argument on the basis of which my learned friends have placed this writ petition was that whether this is permissible at all in absence of the express permission under the extant rules, whether the rule related to the making the application and rule related to the qualifications obtained within the zone, that is the last date of application, whether that can be allowed. My Lord, in my humble submission, this action was a double action. They have extended the time to file the applications, last date was extended, as well as Lordship, a class was allowed to participate in the examination upon this fulfilling this condition, whether he is pursuing B.Ed like us or not. Now, Lordship, this was issued on 12/6/2023. Now, Lordship, here I add this with my first argument that why they were negligent. Now, Lordship, this was issued on 12/6/2023. And this petition was affirmed. My Lord, kindly come to the affidavit page. February 2025. I don't know the date, but this was on February 2025. So someone who was expected to be vigilant, found to be negligent about the entire process, suddenly went to write the examination, and without writing the examination, which is quite unexpected that a person going to the examination hall, instead of writing the examination, will be engaged in finding out the students who have no training degree within that zone of consideration. So I expect that they have undertaken that duty also, that whether they have fulfilled it within that particular time, which requires the individual information. So they have filed this writ petition and they took a chance. Well, this was affirmed on 12/2/2025, and examination was held on the notification was issued in 2024. Main examination syllabus was uploaded. So therefore, main examination.
Notification was issued on 23.
23. Writ petition was filed in 2025. And writ petition was found on the basis of the fact narrated by them. It is their awardment in paragraph 7. So that is the source of knowledge. Now they have challenged it. They have obtained the interim order. So that is the first point which I want to emphasize on. Now, the second question is that whether they have qualified or not. First limb is that whether they have belatedly approached. Number 2 is whether they have qualified or not. And if it is found they have not qualified, then, my lord, it would be a writ petition at behest of a group of unsuccessful candidates, whether that is maintainable in law, eye of law. So that is on the maintainability. And law is very clear that after being unsuccessful, whether a set of candidate can challenge, when they can challenge and when they cannot. And this is a clear situation where they cannot challenge this action of the Madrasa Service Commission belatedly by filing this writ petition after being unsuccessful, because, my lord, the if your lordship kindly take up my the affidavit of opposition filed on behalf of respondent. Now, what is our affidavit in opposition, my lord, which was filed? I will refer to one document. We have filed one affidavit in opposition by virtue of in Can 1 of 2025, because they have given their Can 1 issue. We were allowed to file our affidavit in opposition to the writ petition, my lord. Kindly come to that affidavit in opposition, my lord. It's affidavit in opposition affirmed by Masood Billah.
Look at the 356 to the affidavit in opposition.
who has been admitted in any of the teachers training course and undergoing the teachers training course can be said to be pursuing such teacher training course and shall be eligible to appear in the teachers eligibility test examination. In view of the discussion made herein above, the petitioners are entitled to appear in the ensuing teachers eligibility test to be conducted by the commission. The commission therefore is directed to allow the petitioners either to upload their online applications or to submit offline applications in the ensuing teachers eligibility test. The certificate to be issued to the petitioners in the event they are found eligible in the eligibility test shall be abide by the result of the present writ petition. The matter requires further consideration upon exchange of affidavits by the parties. The respondents are directed to affirm affidavit in opposition such and such. In view of the position discussed, the commission may consider the issue of corrigendum to notification for the ensuing teacher eligibility test. Though there was an advice from the court that may consider the issuing of the corrigendum, but the reading of the corrigendum doesn't show that this was the outcome of this particular order. If otherwise, also, the commission was empowered to issue that corrigendum. That power falls within the commission's power to issue the corrigendum to any of the notification or any rules, guidelines whatsoever. But extant rules, my lord, in my humble submission, the law related to this depends on the extant rules. Whether extant rule permits something to be done, that can be altered even the game once the game starts. That's the rule, my lord. In my humble submission, the extant rules related to the qualification is the extant rules which are framed by the NCT, not framed by the Madrasa Service Commission, because this is an extant rules on qualification. This is an extant rules on qualification for the appointment of the assistant teachers in the madrasa, which are to be followed in accordance with the NCT guidelines. We are required to examine whether the NCT guidelines permits such candidates to participate in the examinations. And your lordship will find that the commission has done the same thing. They have allowed this group of the candidates to participate in the examination in terms of the NCT guidelines, as well as the commission has also extended the last date of making the applications. So if the commission have the power to extend the time for the last date of making the application, and if the commission has the power to follow the NCT rules, which is the law operating on the field, then lordship, this action can be justified. Now, lordship, I will place few of the judgments, and I will be saying that this is permissible, under which circumstances this change is permissible. That happened, right? No, we can only. Lord, you kindly, this is 2021-14 SCC 486. Omkar Singh. So Omkar Singh, my lord. Paragraph 5 onwards. Now, in the state of Uttar Pradesh, a government order dated 7/9/2011 had been issued for conducting teachers' eligibility test, which provided that a candidate having BA, BSc, BCom and TTC passed are eligible to appear in teachers' eligibility test. And subsequently, the state of Uttar Pradesh issued another government order dated 17/9/2011 in the modification of the earlier government order dated 7/9/2011, whereby, para 5, sir, whereby the eligibility guidelines came to be amended in pursuance to the NCT notification dated 29/7/2011, and in place of BA, BSc, BCom, words graduate came to be substituted. Thereafter, the aforesaid government order dated 7/9/2011 and 17/9/2011 came to be amended. White government order dated 4/10/2011, and for that examination, such candidates were authorized to appear who have passed TTC recognized by NCT or who were appearing in the last year examination of TTC. The last date of submission of the applications for UP TET was 18/10/2011. The UP TET examination was held on 13/11/2011. On 25/11/2011, the similarly CTET examination was conducted by the central government, authorizing such candidate to appear who were pursuing the TTC but have not passed the TTC examination. Thereafter, on 17/4/2013, the government order was issued for conducting UP TET examination 2013, and the consequential office orders were issued. The learned single judge in Vinod Kumar Singh versus State of Uttar Pradesh passed an order dated 13/5/2013, allowing as an interim measure the candidates pursuing TTC to appear in TET examination, making the result subject to the further orders of the court. Thereafter, the government order dated 17/4/2013 came to be issued for conducting UP TET examination 2013, and consequential office orders were issued. Then a bunch of writ petitions came to be filed before the High Court by such candidates who were pursuing TTC or appearing in the last year examination of TTC with the prayer that they were being deprived to appear in TET on the ground they have not passed TTC. The High Court disposed of the aforesaid bunch of writ petitions, directing state government to take notice of the guidelines of the NCT for eligibility and issue appropriate instructions or government order in the event it is found that writ petitioners are also entitled to appear in the examination. In compliance of the aforesaid order passed by the High Court, dated 13/5/2013, a government order dated 15/5/2013 came to be issued by the state government, modifying the government order dated 17/4/2013 and these office orders providing therein that such candidates may also be entitled to appear in teachers eligibility test who are appearing in teachers training course examination. It also provided that such candidates will be allowed provisionally to appear in teachers eligibility test examination with the condition that teachers eligibility test examination passed certificate will be valid only after passing the teachers training course examination. The UP TET examination was held on 17/6/2013 and 28/6/2013, and the result of the UP TET 2013 was declared on 13/11/2013. At this stage, it is required to be noted that the respective appellants, original respondents before the High Court, are the candidates who have passed UP TET examination. However, at the relevant time when they appeared in TET examination, all of them were pursuing their TTC course. It appears that thereafter the government order dated 11/7/2013 was issued for the assistant teachers of maths total number, that is 29,334 posts of assistant teachers of the senior basic school class 6 to class 8. The government order further provided eligibility educational qualifications as BSc and teachers training course recognized by the NCT and the TET passed. The academic qualification was modified in place of BSc and it was made graduation with subject of science and math, as the case may be. As against the aforesaid vacancies, the candidates who have passed UP TET examination in 2011, CTET examination 2012, UP TET examination 2013, and CTET examination 2013 were eligible to apply. The last date of submission of their application was on 30th September 2013, which was further extended to 10/10/2013. All appellants applied pursuant to the aforesaid advertisement. All of them were appointed and all of them are working as assistant teachers in the respective subjects since 2015. After a period of 2 years, in the year 2017, a bunch of petitioners came to be filed before the High Court challenging the appointment process initiated by the state government by government order dated 11/7/2013. Twofold submissions grievances were made. Firstly, that the appointments have been offered to persons who are ineligible in terms of the qualifications specified, inasmuch as they do not have science or mathematics as one of the subjects in the graduation degree. And secondly, the persons who had not passed an examination or were not in the final year of their TTC had also appeared in teachers' eligibility test examination, which was impermissible, and that such persons have also been appointed. The learned single bench of the High Court disposed of the aforesaid petitions by judgment dated 8/5/2018. The learned single judge observed and held as under Prabhat Kumar Verma case, in view of the notification issued by NCT dated 11/2/2011, as well as the government order issued on 15/5/2013, in the inescapable conclusion culled out from the provisions is that only those persons are eligible to appear in TET examinations who have acquired academic and professional qualifications and have either obtained training qualifications or are pursuing any of the teachers' education courses. In view of the interpretation given to the word pursuing by this court, which stands implemented wide government order dated 15/5/2013, it is clear that only those persons who are in the final year of their teacher training courses alone would be entitled to appear in the TET examination. The appointing authority, therefore, is directed to ensure that before appointment letters are issued to the candidate, he and she must have passed teachers eligibility test after completing a training course for which persons were in the final year of their training examination. A person who does not come in either of the two categories would not be issued any appointment order. The state government shall implement the government order of 15/5/2013 and circulars would be issued for its strict compliance by the appointing authorities. The appointing authorities shall also clearly state such fact in the appointment letter issued by the candidates appointed as assistant teachers. This takes of the court to be the first limb of petitioners' grievance regarding those who have been appointed as assistant teachers, even while they had not even completed the first year of their teacher training courses. Shall we stop today? I need another 10-15 minutes time. So, shall we complete this now? This judgment is then I'll. This takes 23 onwards. This takes the court to find the limb of petitioners' grievance regarding those who have been appointed as assistant teachers, even while they had not even completed the first year of their teacher training course. By way of illustration, some of the petitioners have annexed materials to show that appointment orders have been issued to persons who have passed teachers' eligibility test even before completing the first year of their training course. Such appointment orders would be inconsistent. Liberty, therefore, is reserved to the petitioners to challenge such specific appointments. Now, I'm skipping this. The process in regard would be concluded within a period of 6 months. 6.4. The judgment and order passed by the learned single bench dated 8/5/2018 was subject matter of appeals before the division bench of the High Court. By impugned common judgment and order, the division bench has opined differently as under. Now, what was the observation of the division bench? A perusal of clause 5(2) of the notification dated 11/2/2011 issued by NCT clearly indicates that a person who is pursuing any of the teachers training courses specified in NCT notification dated 23/8/2010 would also be eligible. It appears to us that this benefit was considered to be given to such candidates whose teacher training course result had not been declared by the last date specified for filling the online form for TET examination. This is why such persons who were pursuing the teacher training course could appear at teachers eligibility test examination. In our opinion, pursuing any of the teacher training course should not be restricted only to such persons who are actually appearing in the examination of the teacher training course. It should also include such persons who have studying the course but examination had not been held. But what is important is that such persons should have been declared successful in the teachers training course. My lord, kindly mark this. The such person should have been declared successful in the teachers training course before the date on which the examination result of teachers training teacher TET is declared. If such interpretation is not given, then even if a candidate does not pass the teachers training course, TET certificate would be issued to him, and this would enable him to seek appointment as an assistant teacher, even though he has not passed the qualifying examination. This clause merely facilitates such person to appear at teachers eligibility test examination, even if the result of the teacher training course has not been declared. This interpretation would subserve the purpose for which such persons were considered eligible. To give any other interpretation would defeat the purpose of the facility that has been provided to such persons. In support of this interpretation, it would be appropriate to refer to the schedule that was placed before the court for the 2011 examination. The last date for filling up the application was 18/10/2011. The examination was held on 13/11/2011. The result was declared on 25/11/2011. The case of the appellants is the persons whose result of the teachers training course has not been declared by 25/11/2011 were issued certificates, and on the basis of the certificates they were appointed. According to them, the result of the teachers training course was declared in March 2012. The impugned common judgment and order, the passed by the division bench of the High Court, is the subject matter of the present appeals. We have heard the learned senior counsel for the respective parties at length. The issue involved in the present appeal is the meaning and interpretation of the word pursuing as appearing in clause 5.2 of the NCT guidelines. The question for consideration is the eligibility criteria to appear in teachers eligibility test examination. It is apparent from the reading of the guidelines framed by NCT, para 5 of the incumbents who have acquired the qualification, academic as well as the professional, can apply for the teachers eligibility test. The second category of candidate who can apply for the teachers eligibility examination was those who are pursuing any teachers training course. The meaning of the pursuing is a person who is undergoing any of the teachers training course. He or she must have been admitted and pursuing the teachers training course which is prescribed as a qualification. Declaration of the result appearing in the examination of the date of filling up the forms, etc., cannot be a criteria to appear in teachers eligibility examination. Therefore, the candidate who is undergoing pursuing the requisite teacher training course shall be eligible to appear in teachers eligibility test examination. The learned single judge of the High Court held and concluded that Prabhat Kumar Verma's case, only those persons who are in the final year of the teachers training course alone would be entitled to appear in teachers eligibility test examination. The division bench of the High Court has gone further and has observed that only such candidates whose teacher training course result has not been declared by the last date specified for filling up the online form for TET examination can be said to be pursuing the teacher training course as mentioned in clause 5.2 of the NCT guidelines and could appear in the TET examination. Therefore, according to the division bench of the High Court, as the last date specified in filling up the online form for the teacher's examination, the candidates must have appeared in the examination and the result has not been declared. These riders are not proper given the clear language used in clause 5.2 of the NCT guidelines. The division bench of the High Court has read into and added something more than what is provided in clause 5.2 of the NCT guidelines. The language used in clause 5.2 of the NCT guidelines is simple, clear and unambiguous. As per the cardinal principle of the rule of interpretation, while construing the particular provision is required to be read as it is and nothing to be added or taken away. Looking to the clear wordings in clause 5.2 of the NCT guidelines, and the phrase used is pursuing, the High Court is not justified in adding the additional riders, such as that to become eligible for appearing in TET examination, a candidate must have appeared in teachers training this course examination, and the result have not been declared by the last date specified for filling up online form for teachers eligibility test examination. As per the dictionary, meaning of the word pursuing means undergoing and the proceeding further. Therefore, a candidate who has been admitted in any of the teachers training course and undergoing the teachers training course can be said to be pursuing such teacher training course and shall be eligible to appear in teachers eligibility test examination, irrespective of the fact that whether by the last date specified for filling up the online form or teachers eligibility test examination, he has in fact appeared in the examination of the teacher training course concerned and the result is awaited. Pursuing the requisite teacher training course is sufficient to make such a candidate eligible to appear in TET examination. Therefore, on a fair reading of clause 5.2 of the NCT guidelines, a person who has been admitted in teachers training course and is pursuing, he or she can appear in teachers eligibility test examination. In the present case, admittedly, on the cutoff date, all candidates were pursuing the teacher training course concerned. Thereafter, all of them have cleared TET examination as well as have cleared the teacher training course concerned at the time when they were appointed as the assistant teachers. All of them fulfill the eligibility criteria for appointment of the assistant teachers. All of them have passed TET examinations and have also passed in teachers training course as per the requisite eligibility criteria. Thus, in our view, ousting certain incumbents by High Court cannot be sustained since they were pursuing TTC and they were clearly eligible to appear in teachers training eligibility test examination and have passed it while pursuing the requisite professional qualification for being eligible to be appointed as assistant teachers. 7.4. It is not permissible to add riders as done by the High Court. The phrase pursuing is to be given literal meaning. The expression rule of literal construction lays down that the words of the statute are first understood in their natural, ordinary, or popular sense, and phrases and sentences are construed according to the grammatical meaning. The learned author G.P. Singh, in Principles of Statutory Interpretations at page 91, has observed natural and grammatical meaning. The words of
It's all right.
Yes.
Now the pursuing candidates, they have been allowed to.
So, my lord, and lordship, the only thing which is to be looked into is the correlation between the teachers eligibility test and teachers training course. Now, these two are guided by the NCT guidelines, which is the outcome of the right to Education Act. And I'll take 10 to 12, 15 minutes time. I will place another 1 or 2 judgments and some provisions from the RT Act and conclude it. I'll fix it.
But Mr. But in all the writ petitions, the petitioners have prayed for cancellation of the candidature of the pursuing candidates.
Yes.
In all the writ petitions.
There are 3 sides. One side, they have all qualifications. They were not pursuing. Other sides, they have academic qualifications plus regarding this teacher, the B.Ed, they were pursuing. And third is the commission. Commission in this case, unlike the others, because from class 8 onwards, we said no, we follow by last date. But because it is below class 8, we have actually followed the NCT object, because we put a question to ourselves, if they are allowed in a TET pursuing, which is absence everywhere, what could possibly be the object? Maybe fresh talent to pull in. So in a competitions, if I get more fresh talent, which is permissible under NCT, we have allowed that.
Yeah, at what stage the verification is done? Suppose a pursuing candidate
Yes.
is allowed to take part in the examination.
Yes.
But subsequently fails to pass the TTC.
Then
how the commission will be informed of that, whether he has passed or not? What is the stage of verification?
That
of
documents have shown, my lord, that
that
note,
part has to be
physical
clear. That
verification.
part has to be clear. A person who has not passed TET, not eligible, because it's a interesting. I would say it's a kind of butterfly effect. Like once someone is allowed, someone means someone who wants to pursue the B.Ed for the purpose of TET, and when TET happens to be the entry, what happens to that someone for the next step of competition? That's the main examinations. Answer is silent, because no law clearly says so, excepting our rule says eligibility, that a person who has passed the TET, he is supposed to be eligible in the concerned examination.
Okay.
Answer is blowing in the air.
After before the final grade. By the time all the pursuing candidates have cleared their
Ashwin.
No, if the TET is
Pale
not
mark
cleared, then no question of it.
Pale mark is spot admit.
Mark is part admit.
Yes,
Mr.
that I think
Sobhusachi
has joined
Chatterjee,
all of us.
learned advocate appearing for the applicants in WPA 3562 of 2025. Due to paucity of time, hearing could not be concluded. Accommodation has been sought for on behalf of Mr. Firdaus Samim, learned advocate. Mr. Samim. আগের দিনের নামটা দেখুন for applicants in WPA 13463 of 2023. 463 of 2023. Is this matter? Follow. 12:30 vacation for 17 June. 17 June. The matter is
17 June.
17 June.
Yes.
Mark Hardin part.
Gratefulness.
Huh? Hardin part mark করবেন সেই meeting আর Hardin.
Everybody is against me. Commission, all parties added, all against me.
All against me. So you have given me that.
pursuing candidates have suffered a lot. Because of the wrong interpretation and my lord, the way it has been put.
In fact,
Everybody
that
are opposing
out
you.
of the track, because the next suffering, maybe now the new government has extended 5 years for all the sufferers. Now those who have lost age, but they will get 5 years more term, so that ultimately, my lord, the most talented person should be in the meritorious places.
Yes, yes.
But the only thing whether Madrasa will
Didn't get
survive
the
or not,
opportunity.
Have.
Didn't get the opportunity.
whether Madrasa will survive or not, that would be the very question. Great.
number.
Lordships, I have a call that
The name of the first contemner be there as you have filed. He is alleged contemner 1 and leave is granted at the name of the Pavan Kandia as alleged contemner number 2. What has been done is the first one has been struck off and the new person name has been made. Correct. As you have filed, Arup Chaudhary will be there.
My learned friend appearing for the alleged contemner said that this person is no longer in the post.
Fine.
So
You have filed as a alleged contemner. Let it be there. Name of Pavan Kundal, he should be incorporated as alleged contemner number 2.
may I do that?
Yes. Do that.
Okay.
On behalf of the writ petitioner led by Mr. Sandeep Doshi. The matter is related to illegal and unauthorized construction. Your lordship pass an order, solemn order.
Affidavit of?
My submission is that your lordship fixed some procedure, but the order was passed by the own motion by the Pradhan without following the due procedure. Kindly come to my lord, solemn order first, my lord.
Where is your order? Where is the order?
14th August 2025.
14th August 2025 is the order passed in the writ petition.
Yes, sir.
Where is the order passed by the Pradhan?
Inspection has been done by the Pradhan Minor at page number 17 of the affidavit of complaint.
Where is the order? After the inspection, where is the order?
This is the report, my lord.
There is no order annexed.
No, you have to find, hear out and then pass an order.
Yes, my lord. This is Nirmal Shaik, is the civil engineer of Panchayat.
After that, after inspection, you have to hear the parties. What was the direction?
Will you kindly come to my lord, page start from 50, my lord, solemn order. Operating portion, my lord,
Inspection for-
51, last paragraph.
Where is the hearing done?
Yes, my lord.
Where is the order that you have heard such and such parties and after that
Yes,
erasing the
There is no hearing notice.
what complaints you are filing then?
There is no, my lord, hearing notice served upon the petitioner, my lord.
Yes.
Alleged contemner.
Dated 31/12/2025, which was received by the Rafiqul Islam. It was evident from the backside of the signature is there on the backside of
Okay. On which date?
the notice dated my lord 30/12/20. Page number 12, my lord.
There is no receipt, my lord.
There is- This one is the release.
Pradhan.
Rafiqul Islam.
Yes, my lord. Rafiqul
My lord,
Islam.
kindly come to my lord, the order, my lord, first. If you lordship want, I want to file exception, my lord.
What exception you will file? We'll
Because
hear
my
out
lord,
the-
no
Why
hearing
are you not
notice,
appearing?
no hearing notice was served upon the petitioner.
Apna-
The order was clearly that
Is
my
to
lord, the party shall be heard upon notice.
হাই করে নিতে যে কোনো করার জন্য আগামী
Not fair. And second.
No, my lord.
31/12/2025. Rafiqul Islam received on the backside of the notice.
There is no time mentioned when the inspection was held, my lord. They just print out the date.
No, what you want to do?
Well, I want to that no hearing, opportunity of hearing given to me to submit the documents, to submit my.
First you said that the notice has not been served upon you. You're fine that from the back
Kindly
over.
come to my lord, first order, my lord. Solemn order passed by your
Did you
lord.
receive the notice? Why did you say at the first instance that you have not received the notice? It is palpable the notice was served upon you.
That notice was, my lord, kindly come to page number 11. First notice.
After that, my lord,
No one to
second-
receive the letter.
And second notice was also served on 31st 12/2020.
There is no, my lord, annexes that I have received. And my lord, there is no time mentioned when the inspection was held. They just put out the date without time mentioning how the parties know that at the time the inspection was held.
That time, my lord. But he
Present.
did not sign the.
And also, my lord,
He was present, but he did not sign.
Yes, my lord.
no.
He refused to sign.
Why didn't you sign?
There also, my lord, direction to serve notice. Upon notice, parties shall be heard upon notice, and representation of the petitioner shall be disposed of by a reason order. Party has granted liberty to proceed to all the relevant records and documents before the Pradhan at the time of hearing. But there is
Affidavit filed by the alleged contemner is taken on record. The alleged contemner, Timothy Saida Mumtaz Begum, Pradhan Khetpur, Dokhin Bar, number 7, Gram Panchayat is present in court. Learned advocate for the alleged contemner submits that upon notice inspection has been conducted on 5th January 2026. However, the hearing is yet to be held. She seeks accommodation to hearing is yet to be held, and the order in terms of the direction of this court has not yet been passed. She seeks some accommodation to comply the order of this court. Place this matter on hmm? 17th June, 2 p.m., 2:15 p.m. Alleged contemner is directed to এটা রুলটা না রুল ইস্যু হয়েছিল বলে দিন তো Here is the report of Deputy Registrar Reed dated 12th May 2026. Para, it is found from the aforesaid report that the contempt rule was served upon the alleged contemner on 8th May 2026. Now, was sent to Special Messenger with a memo number 238 MD dated 7th May 2026 and has been duly served. এই কথাটা থাকবে উপরে তারপরেই যেটা বললাম the appearance of the alleged contemner is dispensed with for the time being. Alleged contemner is directed to file affidavit of complaint বলেছি আগে না on the returnable date.
Good.
Alleged contemner directed to file affidavit of compliance on the returnable date. AL and OM की administration? Register AL and OM administration? और it is the report of Assistant Registrar 9 dated 8th May 2026. It is found from the aforesaid report that despite rigorous searching, the 5 files of TCR, trial court records, TCR, trial full curriculum, TCR, could not be traced out. Stop. However, the searching is still under progress. Department is directed to take further steps to trace out the remaining part of the trial court records and furnish a report on the returnable date. Of the 4 weeks for it. Let a copy of this order be sent to learned Registrar L and OM High Court Calcutta for necessary action. Thank you. Not today.
41.
Lord, we were to file the notes. 3 corrections I've made. My Lord, kindly pass it over. Before your Lordship rises, I'll come and tender it, my Lord. Before 4:30, my Lord, before your Lordship rises, today I'll come and tender the notes. It will be stitched, my Lord.
Next week you file that.
Next week. It's ready. If your Lordship wants it today, I can give it, or tomorrow, whenever, my Lord, we'll just file it. Because arguments are concluded.
Mr.
Very
good. Not today or next week.
Not today.
In this matter, I am for the petitioner. I am led by Mr. Suprabhat Bhattacharya.
For the respondent number 1 and 2.
In this matter,
The respondent number is dedicated freight corridor on behalf of the Mr. Sutendra Agarwal. Additional.
এই যে রেকর্ডস গুলো ছিঁড়ে যাচ্ছে না। দেখো সঞ্জিতকে বলো ভালো করে করবে একটু। আগেরটা ছিঁড়ে গেছিল লাগিয়েছেন, এটাকেও ঠিক করে দেবে। None appears on behalf of the state respondents. Petitioner. And so you're appearing for?
Union of India. Respondent number 1 and 2.
Petitioner and Union of India
Added
represented.
party dedicated freight corridor, Lordship. Added party dedicated freight
Okay.
corridor. Restaurant number 8.
Wait, respond number 8. Learned advocates for the petitioner, array respond number 8 and Union of India represented. For instance of justice matter is adjourned. Learned advocate for the petitioner is directed to serve. You have to again serve upon the learned GP's office. You have to serve the copy also then.
That's already আমরা সব করেছি তো ফোন করি
An advocate will be petition directed to serve copy of the writ petition and pleadings in the office of the government pleader, High Court, Calcutta. By the returnable date, release this matter on 17th June.
Yes, Your Lordship, I am appearing for the petitioner. My Lord, kindly appreciate my state of affairs, how I am suffering. My Lord, this is a matter of 23. Today, we are in 26. Now, pleadings are complete. Now, the short, my Lord, point is that, my Lord, acquisition proceeding has been done, my Lord, before 62 years. When my grandmother was alive. My Lord, under protest, compensation was paid. I am an officer of the court. I will not suppress anything. That is my first duty. Now, the land was taken. If Your Lordship kindly takes my writ petition once, kindly see the sorry state of affairs, how we are spending our days. Page 20. 62 to বোধ হয় না? 62 to 62, that proceeding has been taken place. Now Your Lordship knows better than me. Land was taken in acquisition for beneficial purpose, and the HIT, that is the Howrah Municipal Corporation, has taken. Now page 23, I have annexed. Your Lordship kindly see, the said scheme has not been withdrawn by the HIT of my writ petition. The said scheme is in the process of implementation. The acquired land is being utilized for implementation of the said scheme. Till date, the land has not been used for any beneficial purpose. And that time, a poor widow lady was compelled to hand over. And another distinctive feature is that, my lord, that till today, my possession is with me. The possession was not taken. Now, what they are trying to do, very recently, my client is here. I came from my client, that due to change of the government, the HIT, by engaging some rowdy elements, are trying to take the possession. Already the caretaker has been removed from there by force. So what I am beseeching, although I have prayed for injunction, but as because now the state is not appearing, because the change of government, the panel and all will be there, my lord, kindly protect me by passing an order of status quo.
How can?
Kindly
Without
protect
hearing
me,
the
my
state,
lord,
how
by
can they
passing
not?
an order of status quo at least. If I am in
It will
possession, I am there.
after the vacation.
My lord,
Until
kindly
and
give,
unless these are served on the new panel, how can this be heard?
my lord, may I,
No.
I am a very, my lord,
I do
as an
understand.
officer of the court, your lordship, kindly hear me for 1 minute. My lord, if, my lord, your lordship, kindly record my
Honorable
submission,
Mitro,
that possession is in my
learned advocate appearing for the petitioner submission.
last occasion also I have served.
The present writ
My lord, HIT has not been changed, my lord, subject to correction. Your lordship, kindly see.
that
State has
present
been
writ
changed. But Howrah Municipal Authority is there, and his panel lawyer is also there.
that by the present writ petition seeks for retention of the land acquired in the year 1962.
5th of May, kindly see, I have complied your lordship's direction. At least kindly record my submission, that possession, I have annexed that possession has been in my favor. Now, during vacation, if they by forceful take possession, they will say that no, possession is right from the beginning. That is the reason. At least record my submission.
For the purpose for which acquisition was made. Pursuant to the previous order dated 22nd May 2026, notice has been served upon,
তোমার কাছে ভিডিও কপি
is received also. State respondents. None appears on behalf of the state respondents or the Howrah Improvement Trust HIT. Fuller পড়িয়ে দাও বলুন date. For ends of justice, the matter is adjourned. List this matter on
Your Lordship,
17th June.
Your Lordship has been pleased to direct to serve a notice.
No.
My Lord, kindly.
I suppose after the panel is prepared, you have to serve the copy of the writ petition and the pleadings to the other side.
Very well, my Lord. May I submit only one thing, Your Lordship? Kindly record my mutation, sir, my Lord. Certificate has also been annexed.
So, Mitra, I have recorded that 1962 there was a proceedings.
My Lord.
The purpose for which it was acquired has not been fulfilled or it has not been used. This is your case.
And also possession.
No.
My Lord, it is on record, my Lord.
We'll see. We are not hearing the argument, Mr. Mitra.
But Your Lordship, my Lord,
17th June.
Your Lordship, kindly hear me. Your Lordship, kindly, my Lord, not be.
Learned advocate for the petitioner is directed to serve copy of the writ petition along with the pleadings in the office of Government Pleader, High Court, Calcutta by the returnable date, 17th June. Next.
State. State is the party over here. One application is for substitution is there, my lord.
Substitution?
Yeah, the state is also a party. Substitution of respondent, private respondents. And sir, আপনারা হ্যাঁ আপনারা আগে তো করেন না
না স্যার করুন স্যার করুন
The petitioner is here. If your lordship sees the representation, there was not to disburse the amount. It is his prayer is that Highways Act compensation was awarded, and so therefore it should not be paid to the persons who have been awarded because we are legal heirs and all those things. Compensation were already disbursed years back. Now, my lord, he has to file a suit, and he has filed a suit.
That is also pending.
Already a suit is pending, madam.
So far as the petition is concerned, my lord, there is no scope. That is my humble submission.
My lord, there is no. Kindly give me some time. Let me give some time, your lordship. There is an CAN application regarding substitution of all, and state is not there. My lord, kindly. Even I am not prepared, and even CAN application is not.
My lord, in this matter, only submission is lordship. That is the case for the proportionate disbursement, my lord. And my lord, that in that purpose, my lord, this suit is pending, my lord.
Even if the apportionment is wrong or whatever, it has been disbursed.
Disbursed. My lord, a read code has no role, my lord. This is our respectful submissions before your lordship.
My lord, there is a case. There is a case. Kindly allow me few days. Kindly keep it after vacation. I shall satisfy your lordship. If I not able to, I myself will withdraw, or your lordship will able dismiss the matter.
We substitute that. We substitute the legal heirs of the deceased petitioner.
Substitution, no,
already substituted.
It was not done. Actually, previously I filed, there was a direction to file a death certificate because in my substitution application, the petitioner couldn't have the death certificate. By way of supplementary affidavit, I filed the death certificate, your lordship.
So I dispose of the CAN application and dismiss the writ petition with the liberty to proceed before the
My lord, so far, my lord, so far, kindly allow me. Kindly give me some time so that I will just try to emphasize my case, my lord. Don't dismiss it, your lordship.
Where is the report?
Give me some time, your lordship.
Where is the report?
I have a copy with this. I have a this is a report in form of eligible person to be audited in Subhashis Bandyopadhyay.
That is the report of the state, my lord.
Kindly seize my lord the report. State already filed the report. Subhashis Bandyopadhyay is advocate of record. Care of Mr. Pramitra.
I'm not prepared, your lordship. I have also filed opposition. There is a report. Everything is there, your lordship. আরে হ্যাঁ আমি ভুলে গেছি এক বছর হয়ে গেছে
Can. No. Robindro Ari. Robindranath Ari is a land acquisition officer. This is of the state.
Yes, yes, that is. It's in page 4. Page 4, second paragraph. And issue number is also there. Annexure R4.
What is the
The petitioner to be benefited.
Yes.
Instead of digressing this matter on a procedure. We have no.
What my learned friend is submitting, I am not disagreeing, but my lord, if your lordship kindly allow me to take some instruction, because it's already 1 year has passed, my lord, some instruction, and I shall, and if it's, and if my clients instructed me, instead of I proceed with the case, I shall withdraw if anything such happens, my lord. But kindly allow me, give me some time so that when I file a writ petition, kindly allow me so that I can, no.
So this suit was filed for title suit was filed for what reason?
There was no. That there is a partition suit. So far, I remember.
Besides during field inquiry,
Partition suit is pending, your lordship, and I am one of the. And I was not a party in the partition suit.
Claim was disbursed.
Including special land agreement.
হ্যাঁ অবশ্যই আপনার
আমার কাছে সুটের কপি উনি
They are not affected. Ultimately, the client of my learned friend's petitioner are illegal.
pending.
He is not disputing that the compensation has already been disbursed.
No, I have not received any compensation, your lordship.
That is the case.
That is my case, and she.
Most taken in terms of yes.
Page 13, my lord.
আমার নাম নথিভুক্তকরণের আবেদন করিয়াছি আপনার কাছে আমার করজোড়ে আবেদন রেকর্ড ভুক্তিকরণের বিষয়টি নিষ্পত্তি না হওয়া পর্যন্ত ক্ষতিপূরণ না দেওয়ার মর্জি হবে this representation of because ক্ষতিপূরণ has already been given that will be
Page 13.
So this representation cannot be considered that's why what remains in this.
Who is the petitioner? Name of the petitioner is Jogesh Singh Babu.
Jogeshwari Singh Sardar.
By the present writ petition, the petitioner seeks for consideration of his representation dated, seeks direction upon the respondent authorities to not to take any steps in terms of the representation dated 11th December 2019 and advocates later dated 30th September 22 and 28th October 2022 towards disbursement of compensation in favor of respondent numbers 8, 9 and 10. 8, 9 and 10. An application being Can 1 of 2024, during the pendency of the writ petition, respondent number 10, Lakshman Singh, has expired. An application being Can 1 of 2024 has been filed seeking for substitution of legal heirs of defendant number 10. Such prayer has not been disputed by the respondents, answering respondents. Accordingly, liberty is granted to the petitioner to implead the legal heirs of deceased defendant number 10, Lakshman Singh, in the array of added respondent numbers uh, 10 respondent number 10A, 10B, 10C. ABC है ना डिफेंडेंट না 11 12 হবে না কেন একজন তো মারা গেছে না সাবস্টিটিউশন হয়ে আসছে 10 ABC ঠিক আছে Mr. Neeraj Gupta, learned advocate appearing for the petitioner, submits that the petitioner made a representation before the authority seeking not to disburse the compensation amount in favor of the private respondents. He seeks that representation made by the petitioner be considered by the appropriate authority. Mr. Swenso, learned advocate, you are for
8, 9, 10.
8, 9, 10 is NHA. Private respondents number 8, 9, and 10, as well as NHAI,
My lord.
submits that already the compensation has been disbursed. Therefore, nothing remains to be decided in the present writ petition. Both of them seek for dismissal of the writ petition. Peruse the report of the state respondents. It is found from the aforesaid report that the compensation has already been disbursed in favor of private respondent number 8, 9, and 10. Thus, the prayer made in the writ petition has become infructuous. Accordingly, the writ petition stands dismissed.
Grateful to.
Can 1 of 2024 stands disposed of. Next. Not to
46, Lord, I will appear for the petition. Lord, it's a case of 2023, but I know, Lord, the trouble which are being faced by the court. But Lord, let it be fixed on next Wednesday, subject to lots of convenient.
Making
Because
it not
Lord,
today,
this Lord, compensation, well, entire structure with land has been taken away for the Lord, the highway road, and Lord, the report which was filed, we have filed the exception, and first round, my objection was at the first round, Lord, we have already crossed the hurdle, because the measurement which was done by them, Lord, ultimately by a report they have said no, some other measurement will be taken place because it's wrong. But the second, Lord, the report filed, we have filed the exception. You know, this is also wrong. This is also wrong. So therefore, Lord, I'm a poor lady, Lord, facing the trouble. If your Lordship kindly will fix it, Lord, subject to Lordship convenient.
State has filed its report.
State filed report, and we have filed the exception.
Oh.
And National Highway Authority also filed the report. If your lordship kindly go through the report and will pass the order on the next date, I leave it to your lordship, my lord, subject to correction. But the entire on records. Our exception, their reports, a National Highway Authority's report, everything. But paragraph 10 and 11 of the report of the state, very vital.
Who appeared for the state?
But appear for the state do not appear. But your lordship will find from the order sheet.
Mr. Ashim Kumar Ganguly.
Yes. And reports disclose that the National Highway Authority already approved our measurement. But they said they only they have received on 2017. And the 2017 2nd November. Receipt number 3803. But they are saying that only receipt number is there, but nothing else. But 11, Lord, kindly see. Thereafter, a letter had also been issued to the National Highway Authority of India regarding joint survey dated.
If there is a dispute with regard to measurement and all, who is to decide as per the act?
But disputes, measurement, Lord, the National Highway Authority has measured.
But
They are
the
approved.
person
But
who is,
they are the
assessing,
disbursing authority.
person who is assessing, he says that the report which has been submitted, it is correct. Now, what is the option left to the petitioner who raises the issue that the measurement is not correct?
No, we have filed the exception, Lord, before your lordship.
As per law, which is the authority who will take it up for measurement and reassessment of that?
But that I will find out and then come back on next Wednesday.
Mr.
But Lord, if you also kindly see the state's report. State's report said that National Highway Authority has approved our measurement.
No, in
And
page
enhanced the
21,
claim.
page 21 of the report filed by the state.
21.
21 of the last report.
No, Lord, I am telling about the report of the Lani district magistrate. Lord, affirmed on 16th of May 2024.
No, this is a report. There was an order passed by this court that they have considered to re-verify and measure the portions which has been left out and thereafter reassess. After that, a report has been filed by some Sri Amit Dave, who is a surveyor, Durgapur National Highways Authority. Whether this copy has been served, this is dated 17 January 2025. Learned Advocate Subroto Bhattacharya find this.
21 টা কোথায় গেল পেজ 21 তো আমি পাচ্ছি না Your lordship is telling about the report
17 January 25.
17 January 2025.
Yes.
এক মিনিট। January not 6th of July 2023. ফিল্ডটা এখানেই এরা April. January 2025 report is not with me, Lord. However, Lord, your lordship, kindly fix it on next Wednesday. I'll come back regarding the authority when the Lord dispute will arise. Because my lord has asked me this pertinent question. I'll come back.
In this report, there is a letter of the additional land acquisition officer. It says that whatever been made by the NHI, that is correct. So I say, if you have any grievance with regard to measurement and left out portion, since the second report has come, because report after report will not resolve the issue. There has to be measurement and proper. So how do you adjudicate under the law?
Measurement, Lord, measurement
If
has
the,
already
if
been
you
done.
have any grievance with regard to
Done. But Lord, it has been demolished. Demolished and road has been constructed.
it is down, not today, it is Wednesday.
Lord, on next Wednesday.
Next Wednesday.
Diplomatized.
Yes, what is the instruction?
My lord, in this matter, my lord, I am appealing for the behalf of the National Highways Authority, my lord. My lord, the proposal, my lord, has been sent to the, my lord, the competent authority for their approval, my lord. We are waiting for their approval, my lord. Some consideration is required, my lord. So for this purpose, my lord, we are waiting for their approval, my lord. We sent an email, my lord.
When?
My lord, we sent a letter, we emailed, my lord, on, this is the 4th February, my lord.
My lord, 14 May 2024, my lord, your lordship pass order to seek instruction. My lord, thereafter, my lord,
After that,
8 days has already taken time. 8 days, my lord, she has taken time before this court to seek
My lord, that is the
instruction.
case, my lord, that's the difficulty.
Yes. No, this is way back in 25, February
My lord,
25. What is
after
the
that,
reason?
my lord, after that, my lord, we sent up for the proposal, my lord, for this purpose, but till well, we are waiting for their proposal, my lord. For, sorry, my lord, for their approval. We'll send the proposal, my lord. And my lord, because of this, my lord, now for this scenario.
What is your prayer?
My lord, they have, my lord, calculated the property as a, my lord, Sali land. That was, my lord, instead of, my lord, Bastu land, wrongly calculated as a Sali.
My lord,
That,
it is
my lord,
a
amount is, my lord, 11 lakhs, my lord, state has been filed opposition. My lord, they have stated that 11 lakhs, some amount will entitled to pay the petitioner.
My lord, that is
Your lord,
supplementary 3G estimate, my lord.
yes, that is admitted. That amount has not paid. So, my lord, your lordship directed my learned friend to take instruction to whether payment has been made or whatever.
My lord, my humble.
Now she has stated that she has sent a proposal. Already, my lord, 2 years, my lord, he has.
My lord, that is the case, my lord. We are sending a
Years
proposal, my
already
lord,
ta-
and there
taken
the state's presence is heavily required, my lord.
State has taken calculated. They have stated that
My lord, they are the dispersing authority, my lord.
Now,
They are
my
the
lord, he has-
dispersing authority.
my lord,
Might be.
release the funds so
What is,
that they
what
will
is
pay.
the status? You have sought
Yes.
for approval.
My lord, we sent for, my lord, till today, my lord, we are waiting for their approval, my lord. My lord, if your lordship,
Either say that it cannot be approved.
my lord,
If the authority said it cannot be approved, so we have to see that whether this
My lord, for this
Rejection of the
part-
approval
my lord,
is
this
made in
case-
accordance with law. Now, how long he will wait for that?
My
Only an instruction that whether you approve it or not.
Yes.
My lord, that is the
Yes.
case. My lord, they are waiting for we are sending the
But
proposal.
how long? I don't know. How long?
My lord,
Letter
and
which
it
has been
for after my
letter
lord,
which you have produced, they sought for 1 week time. It is February 2025.
my lord, after that, my lord, since my lord, there is the situations, my lord, grant us a last chance, my lord, and lordship, give us a last chance, and lordship give the direction, lordship, to the state, lordship, to appear and send us this approval, my lord.
You have sent this letter to whom? Addressed to which authority?
My lord, that is the my lord, the competent authority, my lord. Land Acquisition Committee, my lord. There is a lordship, even their committee has been formed, my lord.
Either you file your report or you pass a necessary direction.
lordship,
If the petitioner is entitled to that, disburse that amount.
Yes.
My lord, in the
You find out.
give a chance, my lord, we'll file a report, my lord. In that scenario, my lord, we'll file a report, my lord. Give a chance, my lord. We'll file a report.
See the record one after the other. You have sought.
Last 2 years,
My lord,
my lord,
this is
he has
a- last
taken
year.
time. My lord, what is the stand, my lord? I don't know, my lord. My lord, state has admitted that 11 lakhs I am entitled to pay. My lord, fund will be released, so I will get
That is not the
my
case, my lord.
payment.
The fund, lordship, the disbursing authority is the state.
What is the
And
problem? I
lordship,
don't know.
lordship, give a chance.
2 years, my lord, 2 years, my lord, he is, my lord, taking time. My lord, 10 days he is taking time. Same language.
Miss Monica Roy, learned advocate for NHAI, submits that communication has already been made through email seeking for approval of the Land Acquisition Committee. You have the copy of the letter?
My lord.
You have the copy of the letter which you have placed?
One copy, my lord.
You go through the first paragraph. If the LA committee says that they are of the view that they are ready to accord approval, but due to some procedural formalities, they take time.
My lord, that is the case, my lord. This is the lordship. We are suffering for this, my lord. Until and unless, my lord, we receive that approval from this LA committee,
No,
my
no,
lord.
LA committee is of the view. The first paragraph says that.
My lord, in
Is of the view that such approval can be accorded.
my lord.
Now, due to transfer of the officers, they need some time to process the formalities.
My lord, that is, my lord, in the year 2025, my lord.
Now, what change has
My lord,
occurred in 2026?
That is the case, my lord. For this committee, lordship, we are suffering for this purpose. My lord. Only lordship, give a last chance, my lord. We will file a report, my lord. We will file a report, lordship, and produce all this scenario before your lordship.
She files a curriculum. Miss Monica Roy, learned advocate for NHAI, submits. Made. She files a copy of the mail, which is
Or
mail
your
dated.
lordship
What is
direct the
date
my
of
lord,
the mail?
respondent to appear
My lord,
personally. So,
February
my lord,
1,
everything will be, my lord, resolved, my lord. Direct
Is the
personally appear
file
the
a report.
respondent.
Let such report be filed on the returnable date. The aforesaid direction is made peremptory. List this matter on opening है दिए दो 17th ही दिए दो
My lord, my humble sub, if your lordship kindly fix the after lordship, since lordship, because of this changes scenario, my lord, lordship, even lordship, I come with your lordship and asking for the time, my lord. After the June, my lord, it is expected, my lord, this scenario will be changed, my lord. This is a change of this
After
government.
June.
My lord, they have, my lord,
After
calculated.
after the my lord, this
filing
summer vacation, my lord. After the summer vacation.
I don't know, my lord. They have calculated I am entitled to 11 lakhs.
Give
Now,
that
my lord,
copy.
2 years he is, my lord.
My lord,
17 June rakho to.
grateful.
This is peremptory. Whatever you say, I will,
My lord,
on the basis of that letter, now I will pass order. You do it within 2 weeks.
my lord. My lord, we
They
will.
are entitled. If they are entitled, why they will suffer so much?
Grateful to your lordship. 17. 48.
But I appear for the KMD in this matter.
Yes.
The matter was lastly taken up.
Corporation minor, Kolkata Municipal Corporation.
I appear for the petitioner.
Dhanyavad.
This matter was taken up by my lord, on December 2024. When my lord, the KMC, my lord, sought for an adjournment, my lord, for filing, my lord, of opposition, my lord.
Yes.
My lord, till today, my lord, I have not received an opposition, my lord.
My lord, I am appearing on behalf of the corporation, my lord. I am praying for fresh inspection with all the parties, my lord. Actually, my lord, in this matter, the corporation is not a party at the time of the hearing. Subsequently,
Upon your lordship's direction, my lord, KMC has been added as a party. My lord, we have served upon them. They appeared before my lord, and thereafter direction was
No,
passed, my lord, for
I have
filing of
directed.
opposition.
I have directed by the concerned authority to inspect the premises with all the parties afresh, my lord. At the time of inspection, corporation is not a party in they have not received any writ petition, my lord.
So how do you submit that? You will be filing an affidavit in opposition without the copy of the writ petition being served. What did you submit?
Corporation added, my lord.
Added way back in.
Added, my lord, 2024. For 2024, and after filing the affidavit in opposition by the KMDA, we have made a party in the writ petition, my lord. For this reason, my lord, I have prayed for it.
My lord, if your lordship, my lord, kindly
direction.
My lord, if your lordship, my lord, kindly takes up the
by all
position.
the parties, including state, my lord.
Well, respondent number 4 has filed an opposition to my writ petition. In that opposition, they have annexed a joint inspection report at page 55.
Yes. Yes.
Where the KMC personals were there.
Yes. We have
Well,
received
they are
a letter
again
only,
prayed
my lord.
for
Inspection made in
Where is that? Page number?
Well,
page
page
number
25.
Page number
25 of the
page number 25.
Of the opposition filed by respondent number 4.
Yes.
KMDA.
Yes. Well, inspection was held on 15th January, 15th February 2024, and corporation added party 4th April 2024. After that, my lord.
Yes.
And we have not received
this
petition, my lord.
inspection, this
At
was
that
found.
time of inspection, my lord. Just give. We have received a notice. We went there. My lord. We have not received at the time of inspection no writ petition, my lord. After adding the parties, we have a knowledge. We get knowledge all the matters, my lord.
No. Why did you cause an inquiry and survey report has been prepared? What for?
What for? This is a project made by the KMDA, and there was a reservoir. There is a reservoir, water reservoir. That reservoir was made by the KMC. And
Lord, what happened? Lord, I tell you, Lord.
Allegation.
Lord, I tell you, Lord. Lord, the total land is of 1.27 acres.
Okay.
Now, Lord, 1.16 acre, Lord, was acquired, Lord, for KMDA. Lord, rest was not acquired. Now, Lord, what happened, Lord? In the rest, this portion, Lord, the water tank has been Lord, constructed, Lord, under Jai Hind Jal Prokolpo. Now, Lord, this has been constructed by KMC. So, my lord, KMC was added as a party by my lord,
And my lord, thereafter, my lord, if your lordship kindly takes up the order dated, my lord, 9th December, my lord, 2024, my lord, there was a specific submission, my lord, 9th December 2024.
Yes.
Yes, my lord, third paragraph, my lord. Mr. So-and-so, learned advocate for Kolkata Municipal Corporation, submits that they have been served with a copy of the writ petition. He seeks to file an affidavit in opposition. My lord, this is of 9th December 2024. After 1.5 years, my lord,
Matter
this
has not
stand
come,
is
my lord, in the meantime.
taken by KMC, my lord.
Let us hear out whatever submissions you have to make, you make your submission.
Here from my affidavit, 2 paragraphs will suffice, my lord. If your lordship kindly takes up my affidavit.
Is required, my lord,
just-
for
just-
this reason, my lord.
Just a minute. Lordship kindly take up my affidavit. Page 3, paragraph 4B and 4C. These 2 paragraphs, my lord, will make the entire thing clear.
Paragraph 4B.
4B is regarding the acquisition of 1.16 acres out of 1.27. We are in possession of 1.16. There is no dispute. Petitioner is not going to dispute. So rest 11 decimals of land was not acquired by KMD. My lord, this land, my lord, if you lordship now kindly come to see. What is the picture? The outcome of the inspection, lordship will find there. That having regard to the complaint made by the petitioners, on receiving the complaint, my lord, we conducted the inspection. A joint survey was conducted at the site on 15 January 2024 by the officials of KMDA, KMC, and the state authorities in presence of the petitioner number 1. And it revealed from such survey inspection that a piece of land measuring 0.11 acres, that is 11 decimals, approximately measurement is given, falls within the Joy Hind Jal Prakalpo possessed by the water supply department of the KMC, which is bounded by so and so. That might have been the KMDA is neither a requiring authority nor the beneficiary.
So how the KMC has come into the possession of 11 acres? With 0.11 acres.
For the measurement, my lord, for the 0.11 acres, for the measurement, corporation wants to fresh inspection with all the parties. For the measurement, only
What
for
is
the
the
measurement.
what is the grievance of the petitioner is that you are possessing that area without being acquired.
Yes.
11 decimals of land has not been acquired. The acquisition has been made in respect of 1.16 acres.
State has filed report. State has state's contention corroborated by the KMDA's contentions corroborated by the state's report.
Okay.
So this 11 decimals of land is found within the possession of KMC.
Okay.
The construction might have been done by the KMDA, but on the at the requisition of the KMC.
Matter, my lord, this is in 1978. This is 1978, my lord.
My lord has seen, if you lordship
acquired in the year 1978.
If you lordship sees,
Lord, I am not
affidavit,
agreed with this acquirement. My lord, what happened, my lord? 1.16 was acquired for KMDA. My lord, rest portion belongs to me. Now, my lord, over that, my lord, KMC has constructed a tank.
For
my lord,
this
for
reason,
that, my lord, we have filed this writ petition.
And for that reason, my lord, we have
will find from my affidavit.
My lord, not other way, my lord. For this reason, we have we wanted to measure the 0.11 acres.
My lord, what were they doing, my lord, at the time of joint inspection? Their personnel were present there. They have signed it.
They have not a party in the meantime at the time of hearing.
My lord, their sign is
After
appearing as
that,
page
the
25.
corporation added party, my lord. After that, after joint inspection,
So now you
make a party.
my lord, their sign is
did not
there.
receive any writ petition, my lord.
You may kindly look to the page 26 of my affidavit. There's a sketch plan also annexed with the report.
Well, this is my report.
26 of my affidavit.
Yes.
Two colored portion is unacquired, which the petitioner is claiming, which was found to be
in paper, my lord. Measurement is required, my lord.
the observation at page 25 and this is the side.
But no,
একটা fix করে তো, একটা report file করুন।
This
He
is
has not filed any exception.
my lord, this is my report, my lord. Please.
Let a copy be handed over, my lord.
Exhibit দেবেন না?
না আগে ইন্সপেকশনটা হবে তারপর।
Easy.
What is the date of this report?
My lord.
It appears to be made on 9th January
9th.
2020.
9 January 24.
Wait, this is original, my lord.
9 January 24.
The report dated 9th January 24.
So you have not yet done any survey.
15th January, there was inspection, KMC participated. Page 25 of my report, affidavit.
There was a joint survey report.
15th January.
KMC, my lord, official signed, my lord.
No, the KMC was present.
Yes.
KMC was present.
The survey,
But the petition was not.
surveyor of KMC was present.
After filing the KMC, এটা pay of our for এটা price. Page number 2, boundary wall has been constructed as alleged in the petition.
What the KMC?
And land is acquired in the year 1978. More than 40 years, the petitioner has moved the petitioner's claim to be found through further joint inspection is required to permanently demarcate the portion for demarcation matter. Only for demarcation. And for the development, the Joy Hind Jal Prokolpo was made.
Every day the matter will be taken up. You will change your stance. Sometimes you say that you will be filing affidavit in opposition. Sometimes you say that you will file
That is the court's
after
direction.
causing inspection, you will file a report.
Direction.
Not the court's direction. You sought for filing an affidavit in opposition. Otherwise, we could.
Filing, my lord. I am
My
filing.
lord, that
my
has
lord.
been specifically allowed by
I
my
am
lord
filing,
on
my
their
lord.
prayer.
Ashun.
My lord, I will be filed, my lord. First, my lord, we have prayed for a joint
Two and two,
inspection for measurement for
advocate.
demarcate the portion.
Seema Chakraborty, learned advocate for Kolkata Municipal Corporation, added respondent, submits that a fresh inquiry is necessary to permanently demarcate the portion
For solution, my lord.
which the petitioner claims by way of the present writ petition. The plot has to be identified through physical survey by the office of BL and LRO Kolkata. And it is to be assessed as to whether the plot is still found in the name of any other public authority in the record of BL, LRO or not. You will not be filing any opposition.
No,
Madam, you say what you are.
No,
This
no.
is a proceedings. Yes. You will not file any opposition.
I want to file the affidavit for extension the period, my lord. For extension the period.
She seeks extension of time to file affidavit in opposition along with the
Well,
the
in the
report.
meantime,
Let such inspection be conducted by KMC within a period of 2 weeks.
my lord.
Hmm?
Fresh inspection.
Affidavit in opposition be filed within a period of 2 weeks after the ensuing summer vacation. Reply, if any, be filed within a week. 3 সপ্তাহ পরের date বলুন তো? Annexing the inspection affidavit in opposition, annexing the inspection report.
After 3 সপ্তাহ পরে। In the meantime, inspection.
24th June. Cause an inspection, annex the inspection report along with the affidavit in opposition, give a copy to him. I will reply within a week, huh? এটা রেখে দিন।
And one thing may I point out?
My lord, only one thing, my lord, your lordship is listing a date.
BL and LRO was present during the earlier survey also. That will reflect from page 20.
No, only we demarcate the portion, the measurement only. For this reason, we want to.
One has given liberty to
Cause inspection within a period of 2 weeks and annex the inspection report along with the affidavit in opposition.
We add one thing, add one line upon due notice to all the parties.
Upon notice to all the parties.
Upon notice to all the parties.
Grateful, my lord, grateful.
এবার কোথায় যাব? Revision.
My lord, in this matter,
49
I was,
after 2 years, the next matter. After 2 years, WBIDC has filed their opposition. I would be taking 2 weeks time after vacation to file our reply. After 2 years, they have filed their opposition.
You have already filed?
No, my lord. Yes, my lord. I have served already, my lord, on 20.
It is filed or not filed?
Not filed.
You are filing today?
Yes.
Affidavit in opposition filed by WB IDC.
Respondent number 1 to 4.
Respondent number 1 to 4 is taken on record, copy served.
ঠিক আছে।
Mr. Swansol, learned advocate for the petitioner, seeks to file reply to such affidavit in opposition. Let such affidavit in reply be filed within a period of 3 weeks after the ensuing summer vacation. 61.
I am for the opposite party. I was continuing my submission. The petitioner's advocate, initially they appeared day after day. That can be ascertained from the order sheets. Thereafter, they abandoned this matter. And the purpose of abandoning is willful. Why I am saying? There are 2 complaint was filed. Their claim is that, I am giving a nutshell, claim is that they supplied by 3 separate invoices. I am the purchaser. According to them, I did not pay, and they have claimed an amount of 1,57,000 and odd as an outstanding. They filed a case under section 420 and 120B, read with section 34 of the IPC. The complaint case first was filed. Out of these 3 transactions, the first 2 in agreed, I am saying, I am distinguishing the fact, then I will come to the documents. The complaint case which was disposed of, there was a conviction, so far the court directed to pay the amount. That amount was deposited in the treasury. That came before the High Court in a revision in connection with that complaint case. That complaint case was for a sum of rupees 27,000 and odd. Out of these 3 delivery, 2 deliveries aggregating this amount, 227. Total amount is 1,57,000 and 2 deliveries for total amount is 1,57,000 for 3 deliveries. 3 times they have delivered.
Is there any other revisional application which is pending?
No. I'm coming to that. One application, the complaint case was filed that there are 3 deliveries. Suppose, my lord. My lord, kindly hear me because it will be more easier to start with the matter. There are 3 deliveries. 2 deliveries was made in the 2005 and April 2005. Then another delivery is May 2005 for 17,000 and 15,000.
aggregating
Take
it
that
to
one.
27,000, 28,000.
Mr. Banerjee, see this order. There are two revisional application which has been directed to be listed along with this.
No, I'm coming to that. That revision application is not, I am representing. These
But the court has
applications,
passed order. Who is
thereafter, subsequent orders are also. One matter, I have given a certified copy, I've given a copy of the judgment, website copy of the judgment. Against me, two matters. In two matters, I was representing these accused persons. In two matters. One is disposed of by the Honorable High Court without any adverse consequences. I have been discharged. Lower court, in the first matter, first complaint case, has held that there is a sum, you need to deposit it, and the court treasury, in the court treasury, I have deposited in the court below. Thereafter, they preferred a revision application, claiming more amount for cost incurred. The cost enhanced the 28,000 to 50,000. That has been paid. The civil revision application has been disposed of in my favor. In that case, here case is that the three deliveries out of these two, one check was issued for 27,000 and not. That is 1,700 and 1,500. And rest is cost. 6,000 was cost. So for this 28,000, we issued a check out of this treasury. Kindly consider. That check was bounced. They filed in the same transaction, they filed a case under section 138, and they continued another case. This case under 420 read with 120B. Court observed that in this complaint, they purposely did not say or suppress the fact that they have already filed one complaint case under section 138 of the NI Act in the same transactions. And court observed during the cross-examination of the complainant, they say that yes, court clearly observed that it is a clear suppression. Then court also, apart from the suppression, also found that the exhibit made by the complainant during the course of trial is also doubtful. Veracity of the invoices, that has been challenged. The handwriting expert was called upon to prove the signature on the invoices of the acknowledging the delivery. If I deliver the materials to somebody, he will acknowledge it. Court says, okay, there is an expert opinion. Expert was engaged at the instance of the complainant at the trial. Then they did not rely upon the expert report. Court said that at your instance, when the expert report is coming, you are not relying upon. Second, the handwriting did not match. Third, no sales tax return. He admittedly in the complaint petition stated that there is a sales tax return. We have not following any sales tax return. No, nothing could be produced. So delivery chapter is overall suspected. It is under suspicion. Then court found another thing. The first two supply date is 21st of April and 20th of May of 2025. Then court said, and thereafter third delivery, 16th of November 2026, after 1.5 months, 1 year and half month, that is about 1.5, 1 year or more. In the complaint petition, they did not say about this check bounce case. There is a check. They altogether claim the entire amount. They suppressed this fact. Then in the cross-examination, specific question was put to the witness of the prosecution. Prosecution could not prove. They rather admitted that there is a suppression. We did not say it. Then expert opinion. Thereafter, the no delivery invoices, no evidence of delivery. The signature did not match. Everything was under challenge. And court disbelieved, categorically stated that I disbelieved the story of the third delivery. Why? My lord, kindly consider, in a practical aspect, if you do not get the payment, your complaint petition averred that precondition of the payment payment condition is my foremost precondition for breaking the supply. Then court said that if you do not have the payment, when the cross-examination question was put to them, the prosecution witness admitted that yes, I have filed a separate case for there is a suppression, and thereafter they say that I cannot produce any delivery challan. Thereafter the documentary evidence was challenged. There is a signature altogether mismatch. There is a bill, challan, invoice, return did not produce. Handwriting expert was called for. That was not relied upon by the prosecution in this complaint case. And court said that if you are not paid for first two deliveries, then merely on a assurance and giving a check by the accused person, you are after 1.5 years, you are making third delivery. So disbelieve the entire story of the third delivery. Thereafter, categorically rejected the documentary evidences. Oral evidences came out from the prosecution witnesses that I am making the transaction by cash. Oral evidences also show that I am a registered dealer of the sales tax and VAT Act. In case of a registered dealer of the VAT Act, he has to produce the challans, returns of the sales tax. Nothing was produced. Then court says that it is not a partnership firm. The accused is an entity which is a partnership. The old father, opposite party number 2, was arrayed as the opposite party number 2 with completely the false assertion. Court said it is not a partnership. Who made it partnership firm? Court astonished on the occasion, and then court has found that it is an unequal fight by a rich man against the poor the person who is generally they are purchasing this for they are the sofa manufacturer. Sofa means they are small thing. They by going house to house they do it. So it is an unequal fight, and the complainant is a Mahajan type of person. He used to supply the foam, and that is the whole crux. No delivery. Court said that it is rather punishment which you are going to impose upon the opposite party. Yes. His old father has been falsely arraigned. Court has specifically stated it is an unequal fight, and this happens in several. And it is the whole case. The trial court discharged me under section 248. Discharge, even without leading any evidence by the no evidence has been laid by the defense. From the prosecution evidence and the materials on record, I have been discharged. Then kindly come to
acquitted, not discharged. Acquitted.
It is discharge, I think, my lord.
Page 48.
Page 48.
248 one. একটু এটা চেক করো তো।
It will be discharged, I think.
2518 of 2011 and CRR 2520 of 2011. দেখো স্ট্যাটাসটা দেখো তো। 2518 of 2011, 2520 of 2011. 2518 18 2520
Acquitted.
2011.
248 কি acquittal? 248 is discharge. 248(1).
It's acquittal, not discharge.
So I have been, but no evidence has been laid by the
defense.
Now kindly come to the few documents, my lord. First one is page number. Kindly come to page number 24 and 25. 24 is that. Kindly come to page number 24. This is the complaint petition I am reading. That the petitioner is expressly most unequivocally mentioned that the strict condition in dealing with the accused that the price is in respect of the sold materials would have to be paid forthwith the purchases. This is the precondition. Then next paragraph. Thereafter, the accused person placed orders for sale of supply of the some foam materials to the petitioner, and the petitioner accepted the said orders, accordingly sold and supplied such materials, being sheets of flexible polymers, foam of diverse quantity to the accused person by invoice number so and so, so and so, so and so. Kindly mark the 3 dates. First one is 2006, he is showing, and thereafter another 2 dates, 2005. Then court says, then kindly come to this is the fact of the complaint petition. Thereafter paragraph 8, to strengthen their case, under section 420, paragraph 8, that the petitioner states that since thereafter the accused person started evading the making payment of the said sum on various pretexts and excuses in respect of the in spite of the repeated request, references, demands by the petitioner and his staffs, the accused person till date have not paid. Thereafter, the complaint petition has been filed under section 420 and 120B. That they are evading. Did not say that in the
disposed of হয়ে গেছে disposed হয়ে গেছে দুটোই yes
then the two things will be apparent from this pleading. First one, nothing has been stated about the taking of the check bounce case. Entire complaint petition is absent on that particular fact. These two deliveries thereafter kindly come to the page number 30. In their evidence they have stated. Now they are twisting the fact of the complaint. The accused gave me a check of on 22nd of September 2006 for rupees 24,000 and I so and again I delivered the goods on good faith. This was his case. He is twisting in the evidences. He is saying all that. Now kindly come to the observation of the court. Now before that, kindly come to page number 31 also. The cross-examination was done. Cross-examination is going on. Now kindly come to the he was cross-examined. Kindly come to page number 35.
No, the complainant is PW2.
Complainant is the PW1 and the staff is PW2. Complainant is
PW1. What is the cross-examination he states?
Yes, I am saying complainant is PW1, Arun Kumar Jhajaria. PW2 deposed on his behalf as a staff of the PW1.
What is in cross-examination?
In cross-examination, I am coming to that. Kindly come to page number 35. Moreover, payment of my leaving few lines from the top.
Yes.
Moreover, payment of my business is served through cash. Responsibility of delivery of the goods is upon the purchaser. Accused told me that they also dealt in the same kinds of goods, so and so. He is now, without having any other alternative, stated that he has. Thereafter, I have only one opportunity to visit the place of business of the accused person, the first delivery of the goods. I am reading from page number 36. Goods to the accused made on 1st April 2005 between so and so. These are not that much relevant. This is the bill dated so and so. There is no signature of the accused. These three bills so and so collectively. He himself states that there is no acknowledgement of the receipt of the delivery. Like that, I never sent any. Thereafter, another paragraph. I am going little fast, my lord. I never sent any notice to the accused before filing this case. No notice. I did not make any complaint to the police. 420. He has no documents. How can he complain? I supplied the goods to the accused second time as payment or first delivery was made. First delivery payment was made, he said. He has accepted. Now in the cross-examination when the cross-examination was declined at the initial stage, after charge was framed, again the prosecution witnesses has been cross-examined. And he is saying that this is more corroborative evidence. The value of the probity of this witness is more. Then after, my lord, page number 38. I could not, 38, last paragraph, my lord. Evidence of the PW is going on, Arun Kumar Jhajaria. I could not, page number 38, I am reading. Last paragraph, I could not produce any written proof to show that I demanded payment to the accused during so and so, 2 days late. Orally, I demanded. He said orally. Thereafter, he said, and his case is that I am avoiding the payment. Then kindly come to the findings of the trial court. I will not go through everything because it is a very lengthy order, but nicely drafted in my respectful submission. That the first thing, the kindly come to page number 45 of the trial court, running page number 45. This is the trial court judgment. Then so and so issuance of a civil case, he has got an ex parte order. The court says that no, civil court is different, standard of proof is different. I am not bound to consider the ex parte order of the civil court, so and so. Thereafter, the first paragraph, after the second paragraph, issuance of a check of being source number for rupees 24,000 and dishonor of the same gave birth to C, case number 3759 of 2007 against the accused by the complainant, which ended in a conviction and a fine of 20,000 by the 8th MM Calcutta on 5th of February 2009. This written as well as oral argument as advanced on behalf of the complainant, except the first one so had no relation with the present case. So thereafter, the court itself observed that this C case was filed for the check bounce. I was referring. There was a check bounce for regarding the first delivery, 2 deliveries. For the amount 28,000 was deposited, 24 was the amount principal, and the 4,000 was reported towards the cost of litigation. That entire amount has been deposited.
In that complaint case, you have been convicted.
In the complaint, this case, check bounce case, I was convicted, but with the direction, if you pay, the court has, naturally it is in 138, that no, it is not a heavy heinous crime. If you can deposit, that is deposited in the court's treasury. So after all, the matter came to an end. That is, I was referring. This episode was completely suppressed. Now, second paragraph, last paragraph. Let us scan the documents. So in this I have already mentioned Exhibit 1 and 2 is of his signature on the receipt of the date at this time. Then handwriting expert. Then you Lordship will go through that these exhibits related to the bills and invoices. Kindly, I am not reading.
Exhibit 1 shows and bears commercial sale tax number such and such.
Then kindly look into few lines, leaving the few lines on the top.
No, it will continue. I keep my land.
15 minutes I will take, matter will be finished.
Other matters will be.
You are appearing in which country? Revision. Revision you are appearing.
64 mm.
Okay. How long will it take?
15 minutes maximum. I will just go through when the defense raised objection against the document, I think it is or was within the knowledge of the complainant, and that being so, the said documents was sent to the expert for decision. Finally, their report was reached to this court, but the report is kept intact and the record of, surprisingly enough, no initiative was taken on behalf of the prosecutor to bring the said document in evidence. This is one aspect. Regarding the veracity of the documents, I am not referring the entire very big order. I am not. Everything was false. They could not show any delivery challan, receipt. There is no signature of the purchaser on the delivery invoices. He himself admitted in his deposition. After that, expert was called for. There was a disparity, mismatch. He did not rely upon the adverse presumption will go against the complainant. Thereafter, kindly come to the next page. I will just short say what is stated in the, and your lordship can look into afterwards at the time of dictation. Now, the story of he disbelieved this is very important. This page I will go. The story of delivery is wholly disbelieved by the court. Why? Now, my lord, after few lines, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 16 lines from the top. Starting from now, the story. Now the story.
Now the story, yes.
Now the story of issuing the checks and its alleged dishonor is totally foreign in this case, as nowhere in the petition nor in the evidence of the PW1 it has been stated. But for the first time, it came at the time of cross-examination of the PW1 and in the argument of the complainant. And the reasons for such successive delivery without any payment, as placed by the learned lawyer for the complainant, is too hard to swallow, where the complainant himself imposed this stringent condition for the alleged transaction, where the instant payment of the delivery was the basis of transactions. According to the complainant, he made the first delivery on 21st of April 2005. Second one on delivery was on 28th of May 2005, simply on the promise of the accused person to make the payment. The amount of the first two deliveries, first and second respectively so and so, and the argument advanced for the third delivery by the landlord is accused made over a check of rupees so and so. At this stage of argument, they are saying at the cross examination that yes, I have got a check. That is why I have made third delivery after 1.5 years. Court disbelieved that when your condition is that you are putting a strict condition that the condition for payment is the precondition of making a supply. How it can be believed after 1.5 without when you are not getting any payment, you are making the delivery. That is the whole thing. What was the amount of the goods allegedly delivered at the third time? It was rupees 1,24,000, near about 8 times of the first delivery. First two deliveries of 24,000. Second one, third one is that 1,24,000. It is 8 times. Court said that if you cannot get any payment and your condition is that unless I will get the payment, I will not make delivery, then how can you making the delivery after 1.5 years? And that is for such bigger amount of 8 times. This is in the findings of the court. Thereafter, other rejection from the court is there in the order of the trial. Thereafter, I am reading from, I have already mentioned that nowhere in the petition of complaint it was stated that PW1 delivered the goods for the third time as accused made over a check to him. This was not the case of the complaint. This is a suppression of the material fact deliberately by the complainant, and the placing such fact is the argument not only contradictory but also suicidal for the complainant.
Yes.
Thereafter, the other thing I am reading, this agreement for complaint is squarely absurd as it out of the reach of the fact of the complainant as well as the four corners of the evidences adduced by the complainant. Even a man of minimum prudence will think 100 times but never agree with the same. A comparative study of the exhibit 1 and document so exhibit received copy dated so and so with the signature of the accused bearing rubber stamp so and so. Here the court rejected the veracity of the document. Then thereafter the what is the want of producing sales tax return also. They could not produce the sales tax return. Then kindly come to the next page. I will not go because there is a shortage of time. I am not going to kill that much of time. A few lines from the bottom, top from the but a anxious case to take part in it is an unequal fight to give lesson. I am reading from 1, 4, 3, 4, 5, 6, 7, 8, 9 line from the bottom. How the learned court was little merciful for this poor fellow, that he has gone into not only the merits of the documents and oral evidences, he has actually introspected the fact that how the falsity of the complaint will kill a person who is coming from a very poor class of person, purchasing some materials from a Mahajan and he is exploiting them. That is why the word unequal fight. Kindly come to the observation. Last, page number 44. 47, 48. Last, 48. Having considered the evidence, the materials presently available on record, both oral and documentary, coupled with the arguments are advanced on behalf of the respective sides. Though it will be irritable, but this court has to produce here that the successive 3 deliveries of the goods to the accused without any payment by the complainant is out and out a false allegation, which is admitted by this written argument. Concealment of the issuance of the check by the accused number 1 dated so and so vitiated his whole allegation. His failure to prove the producing the sales tax return that the goods sold and delivered actually occurred on so and so, that is third delivery 16/11/2006, and the sales tax had been deducted, non-examination of handwriting expert, causing his report as a part of the evidence to prove that the signature bears on the receipt date is or was none but the accused number 1 when the specific objection was raised from the defense. At the time of admission of the said document in evidence, the report was called for at the instance of the complainant. Arrowing of the accused number 1 as accused in this case, when neither it is proved that he is connected in any manner in the day-to-day affairs. He is talking about the arraying of the opposite party 2. Opposite party 2 is my old father, who is in the meantime he has died, expired. Kindly note it. Even to punish this accused, the son to be punished with that intention, his father was wrongly added. That is the observation of the trial court. Then kindly come to the appeal court's order. They prepared an appeal against my acquittal. They prepared an appeal, and appeal court straightaway affirmed the order of the trial court. And appeal court said that it is a no person can be, actually he has taken 2 delivery and he has paid the amount. 3rd delivery is doubted. Every document inch by inch was measured by the learned trial court. 3rd delivery is a false. To create some pressure, the story was given at the stage of the evidence by the complainant. And what is written in the, that is why appellate court, without going into any other factor, affirmed the order of the trial court and says that a person cannot be punished twice. Once he has paid the entire amount, what is actual delivery, he cannot punish, and he affirmed the judgment of the trial court.
Okay.
Kindly decision with the reason. Page number 3, running page 3 of this order of the appeal court. Peruse the memorandum of appeal, the impugned judgment and order dated so and so, passed by the learned 11th Court, Calcutta, and the petition of complaint so and so, Indian Penal Code. At the time of hearing of the criminal appeal, none appears on behalf of the appellant. On the repeated cause, the learned lawyer of the appellant also filed a petition stating therein that he does not intend to represent the appellant, because they have now everything has been disclosed, the suppression, the falsity. They appeared, appellant, they purposely did not attend. Even they paid for adjournment, court passed the order, the appeal court passed the order on merit. On the date of hearing of the appeal, they were not there. So, said the learned lawyer of the appellant also filed a petition stating therein he does not intend to present the appeal. He has no instruction from his client. Having heard the learned lawyer of the respondent number 1 and 2, in course of the argument, learned counsel on behalf of the respondent has pointed out that the PW has stated his examination in chief that he has filed a separate case against the accused for dishonor of the check. Learned lawyer for the appellant further submitted that no one can be tried or convicted twice for the same and different offences on the same fact. On that score, the entire, relying upon the entire judgment, thereafter the judgment of the appeal court affirmed the judgment of the trial court. This is the case. Now, 2 judgments I will refer and my arguments. Well, these are not new thing, but to strengthen my argument. Now, one judgment I will show your lordship. What appeal court, because question may come, what appeal court will do, whether he will adjourn the matter or decide the matter on merit. The law says that Supreme Court decision is that. Kindly see the paragraph 15. I will not read the whole thing. Is that 386 is the provision for appeal, and that provision the court of appeal court cannot wait for an appellant, and rather he is not bound to adjourn. He is not bound to adjourn, but he has to dispose of the appeal on merit. Appeal was disposed on merit. The second judgment on the same issue, I will give to your lordship, that the paragraph 14 of the second judgment on the same ground. These 2 judgments will say that the appeal court also acted without any irregularity, not bound to adjourn. If somebody takes the ground, I have not been represented, the lawyer tried to seek an adjournment, but he could not achieve that. The court decided the matter on merit. And the judgment says that I can decide the matter on merit, and the Supreme Court says that the appeal court has to decide the case on merit without adjourn the appeal. He is not bound for giving adjournment. And third one, I am giving for abundant precaution that a civil case was also filed against me. An ex parte degree by suppression was obtained from the city civil court. Very first paragraph of the trial court's order, you will also see that this civil court judgment is there, and civil court judgment, ex parte judgment, court said that I am not bound by the civil court judgment and order because the standard of proof of the civil case and the criminal case are different. Court disregarded the fact, independently examined each and every document, disbelieved the fact of the third story. Paragraph number, my lord, kindly see, paragraph number 19. First one is paragraph 15. Second one is paragraph 14 and third one, paragraph 19. These are the three judgments. So in nutshell, my lord,
Number 19.
page number 19, that the civil case standard of proof is different, and I am not bound to consider the civil court's order and judgment. Not bound by any under any law. Ex parte order they have got like this. So, my lord, the point wise in summation, if I say that the whole case based on the falsity, the trial of the documentary evidences, it was found that the document is lacking of its veracity and legality. No expert opinion was relied upon, even it was called for on the at the instance of the prosecution. Fourth, that the accused was languished in a false criminal case. This is the case was started in the year 2007 and 2026. The accused number 2 is already expired. Only Raju Rahman, accused number 1, is there. Fifth point, my lord.
File the death certificate of accused number 2.
Accused number 2.
File the death certificate of
I am not file. I can file, but it is not required. I can rely upon my instruction I have taken. His father is no more. And court also found that this has no involvement. Where I have read is it an unequal fight? There also the court observed that he has no role to play. It is not a partnership.
File the death certificate of accused number 2.
And the precondition I will file. And my lord, kindly see that even they could not produce the sales tax return. In the complaint, if you losses go very normally, they have stated I am a registered dealer. In the evidence, they have stated I am a registered dealer of the VAT. In the evidence, it stated when asked for that you please produce the challan, the returns of the sales tax, could not file. Then finally he avoided responsibility by saying that I was making the transaction in cash. It is wholly a unholy person who has completely in a false case languaged this accused person from 2007. That is why this case is liable to be dismissed.
What was the other revisional application filed for? 2518.
In that cases, we have no instruction. This was sometimes order was passed, several matters was there. I have no idea. They have only 2 cases. Somehow it was my lord, you need not to be worried. These are the 2 applications. These are the 2 cases.
There was a previous order of this court where there was a direction to list CRR 2518 of 2011 and CRR 2580 of 2011 along
I am not representing the accused in those cases. I am only now this case and another case. I have given the copy of the order. I have given the copy of the order from the very first day. These are the 2 applications when I was a separate case.
ওটা ডিসপোজ হয়ে গেছে না কি দেখাচ্ছে আমাদের 2518 disposed. একটু কপিটা একটু লাগবে
My lord, kindly consider one thing, my lord, my rule submission. It is not a case, my lord. From 2007, if a person is pestered in a false litigation, they, by going into that revision, they have demanded a further sum after payment of the first case I am talking about, of the 28,000, that includes a cost of rupees 4,000. They demanded 50,000. Then balance amount we have to pay. And I'm not relying on that, but it is the fact. Kindly consider from 2007 and this is 2026. I've been being pestered every time the complainant's advocate was there. Now within 2-3 days, last 2-3 days, he abandoned this matter purposely. It is a clear-cut case of the creating pressure on a person. Kindly take note of the fact. The Lordship is at liberty to pass a proper appropriate order. It is a false case. If a false case has been filed, what is the remedy? Apart from the
Heard, Mr. You have concluded your
both the courts ultimately acquitted. This court, though is not bound to appreciate the evidence, but I am giving the prima facie there is no case.
heard Mr. Swaroop Banerjee, learned advocate for the opposite party number 1 and 2. He concludes his argument. The petitioner, none appears on behalf of the petitioner. He informs the court upon instruction that no. Mr. Banerjee, learned advocate for representing the opposite parties, upon instruction, informs the court that opposite party number 2, father of opposite party number 1. What is his name? Opposite party number 2. Mohammad Basiruddin. He is the father. Mohammad Basiruddin has already expired. Learned advocate on record for opposite parties numbers 1 and 2 is directed to file the death certificate of opposite party number 2 on the returnable date. Next week रहेगा तो order. कुड़ी तारीख কিছু আছে এটা অপরে আগে অর্ডারসটা দিয়ে তারপরে করবো 20 তারিখে কি এটা করলাম মনে হচ্ছে অরিজিনাল সাইডে কিছু আছে না ওটা ওয়েডনেসডে ফ্রাইডেতে ওই লাস্ট ডেতে রাখবো না আপলোড করে তাহলে to be mentioned দাও আগে ডেটের এটা করবে hearing concluded release this matter under the heading to be mentioned on 17th. Hearing has been concluded. The matter is placed under to be mentioned. On that day, you produce the death certificate of opposite party number 2 and we'll conclude on 17th June.
At 3 p.m.
Yes.
To be mentioned. Yes. Grateful.
Yes.
Deeply obliged.
বাকি কোনো ম্যাটার নেই
Next item, Lordship. I am paying for after vacation because learned advocate for the state will not appear even probably next week also.
I'm also praying the matter to be disturbed.
On the joint prayer of the petitioner and opposite party number 2. Release this matter 1 week after the vacation.
I'm grateful to you.
My lord,
Matters have been released for the day.
my lord.
Can it be taken up any day, my lord, before vacation?
What is the matter?
Election process initiated by Not.24 Gorgonas. What has happened since 1.5 years, they have not filed the report. The last occasion of the direction.
This is 2009.
2006 selection process. What has happened? They intentionally now reduce the cutoff and accommodate some candidates.
the petitioner has better marks than the those candidates.
88 and 89.
88 and 89.
Oh.
It is fixed by your lordship, but the time is not mentioned. That's why.
Let it be in the list then. It is hearing a copy as well next week. After the vacation, you mentioned. Because in 1 week, it will not be possible.
Date and time.
Is mentioned after the vacation.
Your Lordship, item number 81, Your Lordship.
Other revisional applications have been released. I was hearing an
It become in the top of the list as there is a direction from Supreme Court for expeditious hearing, Your Lordship. And that order was also passed in 2024 October.
Which one? Which one?
Your Lordship, item number 81.
What
I'm
is
for
the
the
order?
petitioner, Your Lordship.
What is the order passed?
Your Lordship,
Where is the order of the Honorable Supreme Court?
Your Lordship, may I please, Your Lordship? Your Lordship, this was the order in which the Supreme Court has directed for expeditious hearing.
You are appearing for?
I'm for the petitioner, Your Lordship.
It is also recorded.
81.
What is the revisional application is against?
Your Lordship, this was a maintenance matter. Everything was done. Hearing was done. There was a direction for maintenance of 5,000. But the husband approached before the Supreme Court for re-hearing of this matter. He proposed before the court that this matter was heard ex parte, and he didn't appear before the honorable court. That's why he couldn't appear, and his observations cannot be observed by the court.
You are the husband.
I'm for the wife, Your Lordship.
Wife.
I'm for the petitioner. And
Petitioner wife or husband?
Petitioner wife. And OP husband preferred this appeal before Supreme Court, and there was a direction for re-hearing. And after that, there was a direction of payment of 10,000, but husband is not paying. Wife is not getting any maintenance from his side.
Opposite parties. You are the petitioner. You were not there on the last date?
No, Your Lordship, they have prayed for time for filing opposition, and the
8th April 2026, this
Yes.
court took up the matter. You are not present.
yes, they have prayed for time. OP has preferred for time for filing opposition, and there was a direction in 2025 for filing opposition.
ठीक है, राघव, the vacation for it. Learned advocate. So these 4 months have already gone. You are receiving the amount of 10,000.
No, Your Lordship, they are not paying. Even after there is a direction from Supreme Court, they are not paying, Your Lordship.
Learned advocate.
Your Lordship, may I
Petitioner.
please mention one more thing, Your Lordship? On last occasion, we have prayed for filing supplementary, and Your Lordship has directed us to serve the copy and come back. Your Lordship, we have served it to the other side, and we want to submit our supplementary affidavit with Your
Leave was
Lordship's
granted.
permission.
Leave was granted.
Your Lordship, on last occasion, Your Lordship has directed to serve to the other side and then come back.
Any leave was granted by the earlier court
Your Lordship,
filing supplementary affidavit?
Your Lord,
Order.
No, your lordship, we have referred before your lordship that we want to file this
Take it back.
supplementary.
Give a notice to the learned advocate for the petitioner of the next date. Learned advocate for the petitioner submits for expeditious hearing of the application. In view of the order passed by Honorable Supreme Court in Criminal Appeal number 4164 of 2024.
Your lordship, on last occasion, we have served to the other side. Your lordship, there is a notice of service.
List this matter on बोलो एक ऊपर दिख रहा है बस ना 17 तो ना ऊपर रहा फिर नीचे आ गए না 17 তে থাকলে আমরা যে 24 তে নিই 24 তে তো ওখানে পজিশন থাকবে হ্যাঁ 17 জুন
Grateful, your lordship.
তো আছে already. Take this back. Copy is there in the record.
Your lordship, can a time be fixed for this matter?
Petitioner is directed to serve a notice to the learned advocate for the opposite party. Opposite party number 1.
Your lordship.
নোটিশে দিলে 17th না হলেও তো আবার 24th আবার প্রেজেন্ট থাকবে না এখানে 24th এটা উপর দিকে রাখবে This is against interim order. Interim or final?
No, your lordship, final order.
Final. चलिए
Your lordship, cannot time be fixed for this matter because your lordship, this matter is coming in the list.
24 on the top.
Grateful. Grateful.
Top mention code. Give
Grateful.